Item 801.
Please, Your Lordship, in the connected appeal, Your Lordships are pleased to grant bail to the co-accused in CONFEDERATION. I'm praying that my bail application may be listed on Friday.
This Friday is not possible, but we can have it first. First.
Your Lordship, I will mention a matter. Your Lordship, this matter was heard by Your Lordship and dismissed. Your Lordship, however, there is a correction in the cause title.
Cause title.
Your Lordship, because of that, I'm not able to get my refund. It has been mentioned as Sector 19, Your Lordship, it may be Sector 16. Because there's a deposit which I'm not able to get. Sector 16 instead of Sector 19.
Make the correction.
Item 1.
Please, madam. Item 1 becoming infectious because
Your Lordship, it's a 302 matter.
He's withdrawing it.
Yeah, but Lordship, it should be cancelled. It's a barbaric act. A girl of 21 years murdered.
Who's before us?
They are, if you.
Who's before us?
Petitioner.
We know they, but who are they? Next case.
Item 2.
earlier,
Dismiss as withdrawn.
but in item 2, the Hogging Council is due to an emergency, medical emergency.
No, last time also. Sorry.
But it's today, madam.
No, last time it was
But it's,
adjourned to enable you to complete your instructions.
but it's,
Do not allow this.
but it's they.
We'll pass over, you ask him to join.
But it's there on bail. They're already on bail. There is no order staying in. They're not figuring. But we just got the news today morning, man. The Hogging Council.
We are passing it over. We are not.
But he's in Australia. The Hogging Council. He's in it. But
We are done.
much of it.
Next week.
But
Next week, complete your instructions to enable the land council to complete instructions.
can we after
Sorry.
Item 3.
alerts in item 2 next week we have some difficulty, my lords. My lords, item 2 next week we have some difficulty.
No problem.
Kindly have it
Join
after.
digitally. No problem.
Let's kindly have it after.
Join digitally. Thank you.
Milords, I am appearing on behalf of the state in this matter. Item 3. We have filed a wakalatnama yesterday, Milords. I am seeking some time to file a report.
My lords, I have joined the investigation.
You're confirming
Milords, even the victim has not been served.
We know that.
Office report.
it.
Milords, we were allocated the matter yesterday, Milords.
My lords,
We
you have long since
one
served them.
opportunity to file the counter, Milords.
Long back.
Milords may have it any time, Milords.
Thank
One
you.
opportunity to file the
You're
counter.
Much
confirming.
obliged.
4.
Item number 4, I'm praying for a passover.
Awesome.
5.
I have joined the investigation, my lord. As honorable court.
Your Lordship had inquired last time. Your Lordship had inquired whether proceedings had initiated on the date of death. Your Lordship, I had actually filed my counter, but it was filed a little late. It is not. Your Lordship, the proceedings were initiated on the date of death itself.
For date,
Please, Your Lordship, FIR was delayed because of the opinion.
then we can't.
So I have joined the investigation on 5th.
Sorry, dismiss.
My lord, 13 months after I delay lordship. And that
No, that's what we checked. Thank you.
Item 6.
I'm obliged, Your Lordship.
Item 6, my lords, had granted us interim protection earlier. This is anticipatory bail. We have cooperated in the investigation. They filed a reply.
We filed our reply yesterday itself, my lords.
What do you say?
On record, my lord. He is
What do you
cooperating.
say?
My lords, he is cooperating in investigation, my lord.
Joint investigation.
He joined investigation, he is cooperating the investigation, my lord.
No, there are two matters, both.
Next.
Item 7.
Item 7, Planet ASD, Mr. SD
Oh,
Sanjay's
counter,
application.
you don't file counter.
being led by Mr. Luthra is on.
Mr. Luthra, counter.
Lord, we were only served on the 20th, not counter. They've not been able to get it ready because they have to show that there are certain incorrect statements, Lord. My Lord may allow me a day's time, Lord, we'll put the counter in. I understand it was a preemptory order to file the counter.
Not another matter is coming up on.
Every day after.
Mr.
Whenever you
ASG. Mr. ASG.
Lordships.
We'll tender the counter, not that day, because I asked them to get it ready today,
No,
but
no.
they've not been able to get the
No
document.
problem, no problem, just 1 minute. We have heard you. Learned ASG is there.
Lordships. It may be listed on Friday, my lords. Another co-accused matter is also listed on Friday, my lords, before your lordships.
We can have it after the occasion.
Lord, that may be better, Lord, if it's convenient.
He is the kingpin, my lords. Therefore, your lordship have been pleased to issue notice and directed that the counter will be filed.
But they served us on the 20th, not had they served us in a little, not
Not
15, they got the notice. They served on the 15th, they took out service.
Counter within the next 2 working days on Tuesday, coming Tuesday.
Coming Tuesday, grateful.
Item 8.
Grateful.
Item 8, Millets have issued notice is already in a connected matter. It's the same accused. Millets, item 8.1 is, obviously it is also the same offense, but the thing is that it is a separate interim order. There is
You issued notice?
Yes, Millets. There is an order, Millets have kept it for 14th of July.
In Rajshri,
That's not as the same.
notice कर देना और इनका tag कर देना.
My lords, my appearance may kindly be taken.
Item 9.
Please, your lordships. Let's I'm praying for parity in this matter with one of the co-accused, and I am 75-year-old lady, your lordships. This is a matter based on non-est factum, your lordships.
Notice.
Let's I'm humbly praying interim.
I accept. My lords, I appear on behalf of the state. My lords, I accept the notice.
Accept notice next week.
This much I am humbly praying interim may kindly be granted looking into the age of the lady.
1 week won't make much of a difference. Let them come and say something.
Grateful lordships, grateful.
Item 10.
Item 10. This is my 6th bail application. I'm coming for my lords. I'm entitled. And according to 479,
Yes.
Item 11.
we're seeking regular bail, my lords. The petitioner is charged with murder, my lords. The only role ascribed to the petitioner, my lord, is that his.
Notice.
12.
Nearly 3 years.
The heroin.
Only 500 grams of heroin, my lord, and
It's
nearly
heroin.
3 years of incarceration. Well, my humble submission, my lord, there has been inordinate delay.
One
in
minute,
trial,
one
my
minute. No, 4 out of 18 have already been examined. There's no inordinate delay.
What's going on? 3 out of 18, my lord.
So 4. And you have 4 or
4
3
is still going on, my lord. And my lord, moreover, there is 2 directions by the High Court to conclude the trial within 1 year. That has not been followed, my lord, in this case, my lord. Page 20, my lord.
Directions issued by the High Court.
No, otherwise, my lord, the issue note gives me liberty to renew my bill after 6 months.
And do that.
That's what we are saying. That's
Then
what
allow
we
to
were
withdraw.
saying exactly.
Then prosecutor under instruction submits that the prosecution shall produce the witnesses on such dates as may be expired. It's all for.
No, the witnesses have been.
For the respondent, for the petitioner submits that the accused shall not take any necessary adjournment. The trial already stands expedited by the High Court. We reiterate the said direction.
As per the High Court. As per the High Court direction.
That's what we have said.
Very well.
Where are you from?
I'm from Kolkata. I'm from Kolkata, madam.
Kolkata.
Yes, ma'am.
Did we speak Latin?
Calcutta.
Are we not audible?
I'm from Kolkata only.
No, did we speak Latin while we were dictating?
I'm sorry.
Yes.
Lordship may adjourn this matter because
No, we are not adjourning.
my lord, in fact, the council is in Kashmir and my lord, he was supposed to appear.
No problem, we'll pass it over. Ask him to join. Ask him to join. He has joined. Yes, sir, it's an intercourt transfer.
Please, Milords, I apologize for my mistake and my failure to inform the Honorable High Court about the pendency of the transfer petition. Nevertheless, the Honorable High Court has punished me by not hearing my petition on merits. So my humble question, which is for consideration before your Lord, whether my failure not to disclose the pendency of transfer petition amounts to suppression of a material fact, and if yes, whether the punishment given to me is proportionate. Milords, it was my sincere mistake, and I apologize for that.
You may do one thing, you may file a review, no problem. You may bring all these facts to the notice of the court, and whatever you are saying orally here, you say there in writing. Simple.
Your Lordship, basically the complete this succession petition has been heard, and it is only pending for Your Lordship the issuance of the succession certificate.
No.
And all the proceedings
What is the include order?
Without jurisdiction, Your Lordship, neither there was territorial jurisdiction nor there was the subject matter jurisdiction. In fact, the succession petition was turned into a civil suit.
You may do one thing, whatever you are saying here, you may say all that to the concerned High Court by in a review petition. Will allow you? Not difficulty.
Obliged, Your Lordship. Obliged.
Commission to withdraw the. Are you withdrawing it or should we dismiss it? Withdraw with liberty to file a review.
I withdraw, Your Lordship.
Sure,
I withdraw.
For
Obliged.
the
Highly.
we have our order.
Item 14.
Lords, a letter has been circulated seeking accommodation.
Item 15.
My lord, the learned AST is appearing on PC.
Lord, this is a matter in which my lords have been
admitted, no?
My lord.
chips. Pleased to grant.
My lord.
May I just point out,
Lord.
my lord, I am aware. My lord,
After hearing the recent order, my lord, your lordship have been pleased to issue
yes,
notice.
yes, yes, I'm aware of that thing, Mr.
And
Solicitor.
they also, my learned friend has made his submissions, my lord. After
Now,
hearing,
my lord, just have a look at, my lord, the tribunal. In tribunal, they argued that 55% is acceptable to them. They challenged only, my lord, with regard to 3 years period. Just look at.
Same order.
No, my lord, kindly, at least look at that part.
Same order, sir. Same.
Obliged, my lord.
grateful.
My lord, without looking at my contention, at least.
Same order, sir.
No, there is no difficulty, but then facts are different in each case.
No problem. Thank you.
My lord, so far this matter is concerned, this may come after vacation, my lords, because
No,
this is.
item 16, what is there?
17. This is a service matter, my lords. No, 16. 16. 17 भी है. नहीं, 15 है. Sorry. भी तो यहाँ है कॉल हो गया.
Any such workers?
Sorry, my lords.
Yeah, how many workers?
It's like seek instructions from the. This is by my
About 2,000 workers. And they are paying already for the last 10 years.
Maybe if this petition were to be allowed, what is the monetary effect it will have on each one of them is what we asked.
2,000 rupees.
Only.
I'll tell your lordship exactly.
Back to your lordship, my lord, after seeking instruction in the matter.
Yes, 9,000 per month is the increase, and they are paying for the last 10 years. They're not telling your lordship that.
Question of law left open.
Yes.
We treat it as a binding question.
Please, madam. But this is service matter, Lordship. Department issued advertisement dated on 28th June 2015. Advertisement. Modification, precondition, agent documents. Lordship, I passed the first year examination on 22 May 2000.
Can you come to page 23?
23. 34. 34. Please, Lordship.
Yes, please.
This is the advertisement, Lordship, for the course of PGT Mathematics, Lordship.
No, we are with you. Our sympathy is rather with you. But you tell us how best we can help you, because you see page 23, page 34 does indicate that you should be fully qualified, having all the documents in your possession as on the date of closing, which is 21st of September.
Lordship, at the time of verification, I given my whole mark sheet to the verification.
How do you relax this condition? Is there any provision of relaxing this condition?
But Lordship, I qualify before the closing date.
Yeah. Have you not seen what we were conversing? But this code doesn't take a minute for notice. We were conversing, we were trying to help you. Before we put that query to you, is there any condition of relaxation?
Lordship, for this, give me 1 week time to clarify, Lordship.
Thank you.
Item 18 is a reversal in first appeal, Milots. I think that the will is proved. Finally, the attesting.
Page 142 will not prove.
No. Yes, correct. The High Court says will is not proved. The High Court reverses it saying will is proved. Kindly see PW2's who's the attesting witness. It's a reversal by the High Court. It's a reversal by the High Court. Kindly see 100.
One minute.
Sorry, Milots. Because I am for the defendant.
Notice.
The status quo.
Item 19.
19 for an adjournment today as the. My lords may kindly consider having it adjourned and have it on.
You ask him to join this.
We'll pass over, ask him to join.
Very well.
20.
My lord, letter has been circulated, my lord.
Item 21.
Wait, please. Under section 99 of Hyderabad Tenancy Act, if it is a tenanted property, civil court jurisdiction is barred.
Now what happens is the High Court takes note of some other proceeding not concerning this land. Please have a look at the High Court judgment. This land is something else. There are 23 acres of land where this respondent was claiming tenancy rights on to the extent of 14 acres only. In that proceeding, he was declared as tenant in respect of 14 acres only. We are fighting for 8 acres where I am the tenant. And please have a look at that.
No, page 96 in the order passed, which is now subject matter of the presentation.
Yes.
What's wrong with this?
That's the what happens is.
This is the order.
Yes, which is confirmed by the High Court. Now High Court says because there was some second appeal pending between the respondent and the landlord, where he had claimed tenancy right in respect of 14 acres. Please have a look at that. Please have a look at the judgment of the second appeal.
No, you please come to the passed by the authority subject matter of the present case.
Yes, yes, your Lordship may please see what he says is simply rejects the application of seeking reference to the tenancy court. What happens is when under section 99, if it is a tenanted land, then the civil court jurisdiction is barred. It has to be referred to the Tahsildar for adjudication, whether it's a tenanted land or not. Now we raised when the civil suit was filed by the other side seeking injunction. I filed an application saying please refer to the tenancy court for framing the issue and deciding it. Now the trial court rejects it on the ground that there is a second appeal, there is a civil proceeding in which this is adjudicated.
Where is that order of
Yes,
position?
please have a look at that. No.
Order of rejection.
Yes. That is at page number 96.
96 is that
Yes, please see para 90, page 98, para 13.
This is not. That order you have not, it's not there. There's nothing wrong in it.
No, this is the order which is challenged before the High Court.
No, please straightway to.
Please.
There were 2 rounds of litigation, one before the civil court, one before the authority.
No. There is a lot of confusion. That's what the High Court also got confused.
No, we have got confused. No problem. Please clarify our.
What? I'll tell you all. I'll just tell you all. What happens?
What is the order at 96?
Yes. No, 96.
You can't prepare Mr. Chaudhary on your legs.
Rejection of our application seeking referring it to the trial. Please have a look at page 96.
The question is very simple. Show us that the property which is the subject of the present petition
Was
not that of the earlier.
Please have a look at page 61.
Okay, 61.
Or page 61.
Yes.
Now, para 3, if your Lordship see, the plaintiff instituted suit claiming specific performance of contract of 8 acres, 35 gunta. This is the subject land, and from survey number so and so, the land so and so 68/33, totally measuring 23 acres and 4 guntas, which belongs to Bhagwan Das. Now, further, it is the contention of the plaintiff that the property was in. Now,
this is the same property which is the
further, just second line, third line. Now, to the extent of 14 acres and 9 guntas, the statutory transfer was effected in that regard. So, what happened? So far as 14 acres is concerned, suit was decreed. It was said that this is a tenanted land, not the 8 acres. 8 acres in I am a tenant. Now, therefore, if your Lordship sees, kindly have a look at next paragraph, para 4. Para 4, bottom, if your Lordship sees. It is contended that the plaintiff is entitled to possess only 14 acres of land of which he is declared as owner, and he is not in possession of 8 acres and 35 guntas. 8 acres is in my possession as a tenant. And therefore, if your Lordship sees the bottom.
Thank you.
Please have a look at bottom. The order, please have a look at the next paragraph. This would clarify what happens is this. The High Court has completely misread it because this 8 acres 35 guntas is not the that. What happens is that's the problem which has happened. Next paragraph, if your Lordship sees, just one paragraph at page number 64. That would clarify the entire picture. Very well.
Lord, in 22, I am seeking password.
Password.
But
23.
please, madam.
Well, the local commissioner conducts the demarcation at the back of the petitioners, my lord.
No.
I'll show that, my lord. I'll show that, my lord.
In symphony we said no.
I'll show that, my lord. My lord, may kindly have
Page 12,
may kindly
para 19, you were there.
page 12, para 19, my lord.
Page 12, para 19.
That is wrong, my lord. I'll show that from there, my lord, from the record, my lord. LC report is, my lord, starting at page 52. My lord, the typed copy is at page 61, my lord. Today on dated 2/1/2023.
There is an objection to the LC report.
Please, my lord. My objections are, my lord, at page 67. My lord, first objection, that is the ground, my lord. The Honorable High Court goes on the proceeding that I have not taken that objection. My first objection is that page 67, my lord. That the local commissioner has not demarcated the disputed property in the presence of the parties and no notice of presence at the time of demarcation of the disputed property, which is to be finally partitioned, and no mode of final partition has been suggested. Thus, the demarcation done at the back of the JD is null and void. This is the first objection that I take, my lords. My lords, may kindly have page 113 for a second, my lords. 113 is the.
You file a review before the High Court.
No, my lords, page 113, may kindly have page 113.
We are saying it.
My lords, what I am submitting is, my lord, the High Court was conscious of this fact. Page 113, my lord, may kindly have. It is not that the High Court was not conscious of this fact. The notice was issued on this case on this ground, my lord. That calculates the submission of the petitioner very well. The learned counsel.
What we are saying is all this, because you see, when we read the order of the High Court records, it accepts in fact the order of the authority below and says that notice, because notice was there.
My lords, the problem is
the notice attached ends with the respect of the report of the LC, dear signatures of the appellant.
My lords, may I submit?
1 minute now. Please, gentlemen.
Please.
And come to page 12.
My lord, I've seen that. I've seen
it.
Please, my lord.
So go back to the High Court and tell the High Court that this particular finding of the authority found by the High Court, finding of fact, is erroneous.
What submission I was making, my lord, I'll go back to the High Court. May kindly have page 113 for my satisfaction, my lord. 113. Because, my lord, the Honorable High Court capsulates my submission there.
Please understand what we are saying. Para 13 of the impugned order and para 17, which extracts the order of the authority.
I submit that in my petition, my lord, that they are wrong per se, my lord. I have to go back to the High Court for review. The problem is, my lord, the same judge, while issuing notice at page 113, has noted my submission.
So then go and tell the judge, no?
My lord, the problem will be, my lord, meanwhile, he has started execution proceedings.
So what will happen in execution?
My lord, they will, my possession. My lord, they are in the process of.
How many years you have put in the bar?
My lord, I know it will not be completed in that much time.
Execution is not completed in a lifetime of a lawyer. Forget about it.
My lord, I am only praying, my lord, I am only making one submission, my lord.
How long does it take to file a review?
My lord, my lord, the courts are closing. My lord, the problem is that, my lord.
Not yet closed.
Commissions of it.
My lord, may only praying, my lord, permission to come back, my lord. Permission to come back in case. Please, my lord. Highly obliged. Highly obliged, my lord.
Lordship. In fact, we are of the view, once opinion was sought, that from the statute, do away with the execution.
Saying also, my lord, the execution never end, my lord. As my lord said.
Trouble starts from there.
Unfortunately, except Article 14 and 21, we don't talk about anything else.
That's the problem.
Lordship, this case is similar to the Lordship's judgment in Mansoor Sahib versus Salima Lordship. There was no oral.
Say that again.
Mansoor Sahib versus Salima Lordship. Lordship authored this judgment, Lordship. Lordship, similar is there, Lordship, because there was no oral partition and the revenue entry would not confer any right, Lordship. Secondly, Lordship, there are two documents that has been relied upon to prove that we have relinquished our rights, Lordship. Both the documents
and dismissal is withdrawn. Huh?
No, Lordship, that liberty has been given because there were some documents.
Some new.
So, Lordship, is status granted. There is a delay of 200 because of this.
Standard order.
Item 25.
May I please, Your Lordship? Lord, that's at the outset, I may submit that, Lord, this is in no way adversarial, my Lord. The only issue is that, Lord, the High Court granted the interim custody of the child to the mother on the weekdays and the father on the weekends, Lord.
At the same time, the High Court also finds that the mother has some psychiatric conditions, my lord. And that report was kept in seal, my lord. My only prayer is, my lord, Lordship may call for that report and Lordship may then adjudicate the issue.
Only for settlement. Only, we are discussing on merits, but only for settlement.
And then Lordship may issue notice on mediation.
Correct.
Yes.
Discuss on merits, but post standard order.
Lordship may not record so, my lord. If there is a possibility, if Lordship can see that.
That's our order.
Yes, Lordship.
On merits, we are not inclined to interfere. However, only for the purposes of exploring the possibility of settlement, considering the fact that the dispute is intercede husband and wife, and pertaining to child, the issue notice for exposing.
Lordship, highly good.
Item 26.
My lords, terminated in 97, reinstated in 2017 with minimum pay scale. It's a case for back wages, my lord.
Yeah, alcohol, sir, alcohol, nothing wrong.
Not only that, the beating also. Well, understandable up to alcohol, but then going beyond that.
Thank you.
Grateful.
Item 27.
This 27 is a eviction petition, although concurrent findings and your lordships have also dismissed a similar petition, granting some time. But the only one point which has come to my knowledge is this, Millards. The landlord is in fact selling these shops to the other tenant holders. There are two shops.
Is there no provision in the statute that if he were to, see, there is an embargo in the statute, some statute, and we are not sure about this statute. But if there is an embargo that he cannot transfer the property, if it is so, then you are right and used in your favor.
No, Mills, I understand. But the question is, Mills, I am there since.
How much time do you want?
Because the time granted by the High Court is expiring on 15th June.
How much more time?
Maybe 1 year, because there are many other eviction petitions regarding the same complex are still pending before the eviction court. So he is not in a hurry to set up a supermarket at all.
31st of 27.
Well, let it be 30th June, Millers. Because I was there till since 1955, Millers. My father had rented this shop. I got it. Because I am 65 years old, I have to set up a new shop.
Oh, 1 year is good enough for you.
Till 30th June 2027.
Okay, my lord is saying that.
I'm deeply obliged.
Item 28.
Item 28, kindly have a pass.
Passover?
Item 29.
A dispute between husband and wife, Milord. Proceedings are pending, proceedings on the complaint of wife is pending for last 29 years, Milord, with no speedy trial, Milord, for 29 years, Milord, in another bench, Milord. Para 6, Milord. On the ground alone, Milord.
My lord has done.
Yes, my lord. Para 6, my lord, on the ground of pendency.
Gentlemen, just look at it.
Yes,
you're not aware of your petition.
Yes, my lord. Yes, my lord.
Yes, what? Yes, what? Your petition before the High Court has been dismissed.
No, my lord. No.
For want of prosecution. My lord has taken out the order. Just see.
My lord, it was. My lord, we have restored it. We have got it restored.
The latest order.
Order. My lord, the office is very efficient.
My lord, again, the system is that you move an application, then it is restored.
Today, there's nothing.
Right? We have filed 10 applications, despite that earlier we had approached on the ground of pendency of this because.
But when you don't appear, what will happen?
My lord, it was unfortunate.
There is no substance.
My lord.
Today, there is no petition pending.
But my lord, we have restored it, my lord. My lord, we had instructed, we have got the instruction. My lord, kindly see on the ground, other ground, my lord. This petition, husband and wife have compromised 3 times.
We are telling you today there is no list pending before any court.
My lord, kindly give me time so that I could place another record. My list after which, Lord, I'll be ready with latest order, my lord. That has been restored, my lord. I have come with the information.
Just pass it over.
My lord.
We'll pass it over because it was dismissed on 7th of May 26.
Yes, my lord. 7th of thereafter we filed the restoration.
Practice, sir.
Yes, my lord.
Where do you practice?
My lord.
आप प्रैक्टिस कहाँ करते हैं?
High Court में.
हाई कोर्ट में ना?
Yes, my lord.
तो ये लिफाफा ब्रीफ नहीं है, तो आपको पता होगा कि 7 मई 2026 का जो ऑर्डर है उसके खिलाफ कोई कार्रवाई आपने की है?
Yes, my lord. Therefore, I say we have filed the restoration. It is possibly restored also. I'll just inform. I have, my lord, I'll get in touch with the concerned council.
तो लिफाफा ब्रीफ है ना?
No, my lord. And my lord, earlier, my lord.
Gentlemen, now enough. Dismiss. What is this?
I'm withdrawing, my lord. My lord, allow me to confirm, my lord. Allow me to confirm, my lord.
Wrong with the?
From the Allahabad High Court, my lord.
Check out.
Item 30.
Yes.
Hey, 30 minutes. Respondent is also present, minutes through VC.
Give the checks. Sir, kindly see whether they are not. We'll just pass it over. We have to check the.
Very well.
Please come.
Wait, please, sir. But in this, we were directed to file an.
What happened in the High Court?
Yes, sir. I'll just surprise your lordship. We have filed a additional affidavit yesterday. It could not come on record, but I'm just passing a copy. As directed by this honorable court, fellows, on 15th, both the sides appeared before the honorable High Court.
You have not.
Yes, madam. We have the matter was preponed also from 30th of.
Now the High Court.
Yes.
Sees of the matter.
We have listed it tomorrow.
Very well.
Wait.
We'll list it after immediately on reopening.
As it pleases.
Lordship, may kindly do it somewhere around mid because I think the learned ASG has taken a date of 3rd of July in that matter.
Middle of July.
Middle of.
They will complete their side tomorrow and we will respond after reopening is
No
over.
problem.
Yes.
We are informed that now the High Court, the matter of the High Court is part heard. List 15 वाला बीच में
Very great.
Item 32, I have circulated a letter praying for 1 week more time and it has been concluded. It was likely to be listed on 28th, my lord. But it is.
Sorry, क्या है?
No, my lord, it has been concluded, my lord.
What has been concluded?
But I have not received the report, my lord, because he appeared 3 times before the committee, my lord.
1 minute, ये pass it over. आप उनसे पूछिए कि भाई वो
Matter was supposed it has been postponed, my lord. Yes, my lord. Yes, my lord.
Affirmatively कर रहे हैं या नहीं कर रहे हैं?
But I have to find out that, my lord.
इसीलिए तो पास ओवर कर रहे हैं.
Kindly take up after a week or immediately after reopening, my lord. Therefore, I will circulate a letter, my lord. Otherwise, I will not want to that's all, my lord.
How many times you want?
Only 1 week, my lord. Not after that.
On our request, pass over. पता करिए.
One of the difficulty is he appeared 3 times, my lord, and it has been concluded. Now that it has been sent to the government for approval, my lord. Kindly see, my lord. We have to find out, my lord. Please, my lord.
Government for approval in the affirmative or not is what we.
Unless it is signed, my lord, how can I say, my lord? Unless it is signed by the committee.
Recommendation is what we are asking.
My lord, unless it is signed by the committee, my lord, how can I say, my lord?
अब यहाँ बोल रहे हैं. Don't say two things.
No, but I am saying it has been concluded, but as far as signature part is concerned, because it is to be signed by the competent authority, my lord. So therefore, I am saying I kindly take up after a week, my lord, no difficulty. Kindly take up during vacation, no difficulty.
We are saying something else.
Yes, my lord. Yes, my lord.
Can you not find out?
Yes, my lord.
That the file has reached at the table of which authority?
Yes, my lord. Yes, my lord.
Yes.
Yes, my lord.
We will get to know.
Yes, my lord.
We are passing it over. Last order not complied.
Last order complied with Malods. I have deposited 2 crores, and although Malods, the office report says that the title deeds have not been deposited, Malods, I have instructions to state, Malods, that the title deeds in respect of the entire scheme have been deposited. This is Malas what I have been instructed to say, Malas, by my instructing advocate. So that is one Malas. Malas, the second thing I was requesting, Malas, would your lordship just have this Malas for a minute?
What is this?
Malas, there are actually 4 FIRs arising, Malas, from the same issue, Malas. Malas, just please, Malas, bear with me for a minute. Malas, I intend to actually settle this. If it can be settled, Malas, please have this, Malas. Malas, the FIR at serial number 1, here, Malas, we are here before your lordships, where your lordships have asked us to deposit this amount. Malas, the second FIR, Malas, your lordships had dismissed on 10th February 2025 against Malas, the same petitioner, on the ground, Malas, that the co-accused, Malas, he had been rejected the bail. Malas, even his SFP was dismissed. Malas, I have filed an MA in this for restoration, Malas. And the third one, Malas, if your lordships will see, the third FIR, I have again, Malas, this is an SLP which is filed, Malas, which is also pending. That has, Malas, been, the diary number has been allotted. All I'm saying is, Malas, I have deposited this entire 2 crores. The principal sum is 1 crore, Malas. This 2 crores which I have deposited will cover, Malas, all the cases.
Who's for the private respondent?
No,
So the state, now we have to issue note, we have to impede the private respondent.
Private,
He's not here.
No, Malas, they were, your lordships are right, because only the state was here.
So you will impede, kya naam hai, batao?
Malas, there are, the numbers are quite big, so I'll have to, Malas.
So you move an application.
I'll move an application. Malas, may I just request your lordships may have it next week, Malas. I'll move, Malas, because these 2 matters, if your lordships can call for at 2 and 3. Malas, would your lordships call for the...
We will not call that.
No, Malas, the MA and the...
No, sorry. Unless it is registered, we can't.
Next week? Very good. Malas, can we have it next week, Malas?
Yes, saying
Very great, great, most great, most great.
In the meanwhile, you see, if you get in touch with the private party or appraise the private party, you can inform the private party. You can also be here. It's a civil dispute, money is purchased the amount, money can be paid. Multiple litigations will come to an end, same point.
If they are not in, yes, Malas, if they're not in possession of the land, we can hand over the land.
The state government is here now.
Because I know your
He has only that much of limitation.
I know.
So you can also get in touch.
Malas, we'll try to get in touch with them also.
Next.
Lordship will permit us to give appearance to slip Malas.
No problem.
Most great.
Malas 34, I circulated a letter, please.
Lord,
Also-
if only the mediation is failed,
Mediations also.
next date, my lord, I submit, my lord, let the party make, my lord, in order to complete this. Because the child is also.
Mediation is failed, let the party remain present on, we have the concern that perhaps with a little bit more effort, parties can amicably resolve their dispute. Please, put your feeling about it.
Grateful.
Lordship, I appear for the petitioner in this matter. Lordship, pursuant to the earlier order passed by this honorable court, the parties participated in mediation before the Supreme Court mediation. However, the mediation could not succeed, and therefore the matter is now considered to be my lordship.
It's a mediation field.
Failed. So that's the end of the matter. Thank you. Dismiss.
My lords, I only have one request, if my lords, because this matter requires some consideration in the sense, my lords, the divorce has been pending since 2019, and the interim application has not yet been decided on maintenance, and it's been 6.5 years. If my lords wish, the parties can, my lords can, if my lords are of the opinion that the parties could come before my lords.
Yeah, he's not saying that. We are not averse to it.
Lordship, the petitioner is not disputing the petitioner is not disputing the responsibility toward the minor daughter. The limited grievance is regarding the retrospective operation of the maintenance order.
1 minute. You are the wife. The daughter is with you. Are you ready for divorce?
Yes.
It's a question of now money only.
Money for the daughter mostly.
Whatever it is.
Yes.
Whichever pocket, it's a question of money. Correct? Yes, gentlemen, we'll pass over the matter. Ask your client.
Your Lordship, in the mediation center, they have recommended and asked me 5 crore for the wife and 1 crore for the child. So that was not possible as per my instruction.
Well, those are discussions in the mediation, my lords. They are
Just
asking
one
for the
minute.
moon in terms
That
of.
are imaginary amount, your lordship. 5-6 crore.
So you do one thing. Are you in Delhi, sir, or are you outside?
I am from Pune, lordship.
No, are you just now in Pune or where are you just? You as a
I am in
counsel-
Delhi, lordship.
You're in Delhi.
Yes, lordship.
Can you come to the court?
Lordship, sorry, lordship, I stay nearby Noida, lordship.
No
The main council is in Pune.
No problem. See, we just pass over the matter. Today there is a revised thought. And she is ready for divorce. You tell us what is the ballpark figure which you want to give for the child and for the mother. And we'll see if the bridge can be kept, and we will call the parties. Otherwise,
Obliged, lordship, obliged. Sure, lordship.
Most grateful to you.
Not in this matter, we have filed the affidavit today morning only. Because we had to get the details from 2 police stations.
Yes, sir.
Lord, we have received their supplementary affidavit this morning.
Not required. Not required. Their mother-in-law.
And the private respondents.
Is not the husband.
Not on record.
Question is not against the husband.
No. Question against the other in-laws, Your Lord.
Lord, grant an opportunity to file a rejoinder in this matter.
What is there? Is it your personal name, sir, or someone else?
No, it's my senior.
We'll pass it over. I'll just call him.
He is not in town, my lord. His mother is unwell. He has gone to his hometown. Kindly grant an opportunity to file rejoinder.
Rejoinder within. We'll have it in the first week.
Lord, can it be placed after the vacations?
Lord, we also would like to place some.
Such of those respondents who have yet not filed their counter may do so within 4 weeks. Rejoinder, 2 weeks, list on position.
Please.
Item 37.
Lordships, unfortunately. We will
Persuade them on any alternative we couldn't persuade.
And likewise, we were willing to furnish an undertaking that we would not give it to anyone on rent for the next 3 years.
Right,
We are willing to use it.
11 commercial properties which have been leased out in the middle.
I sought an eviction.
Succeeded on bona fide necessity not being established.
Milords, with due respect, 2011 I filed an eviction petition. Tenant cannot usurp the property for eternity. We are willing to say and give an undertaking, and I'm putting this across the bar today also. For 3 years next, we'll use it for our personal use.
Which is that property?
This is N18,
Entire N block virtually being.
No, but this
particular. This is that M block.
No, this is
not. The entire N block of not.
What is crucial is N18, the property over which the moot is there, is on the outer circle and on the ground floor. The rest of the properties which they are talking about that we claim to have are all ground floor upper properties. And none of them are ground floor. They are either second or first. I'll just make the chart clear. Milords, we just for a moment have.
The counter is given.
Yes,
yesterday.
I'll furnish.
It is incomplete. I have no problem. We can go on. I was only requesting her if the.
I'm so grateful.
Give her the papers that was.
He's a young.
Yes, Lord. I was only asking. But I was pointing out only papers not being annexed with the counter. That's all.
That's all right. You kind
My learned friend will have.
Can we just request you, please? Let
Milords.
her open.
I'm so grateful. Milords, we filed a counter yesterday. Mediation failed on last Thursday. Overnight, we've prepared a counter. Counter served upon them is duly complete across the bar. I'm making a submission and the AOR in the matter with full papers and fully numbered. There's not a single sheet missing. I'll now open Milords. Milords, may for a moment have the property table annexed by them on page 2.
Now, what is that are you arguing? Would you intend to
Milords,
argue?
I have an offer I'm saying, which we also said.
So you're not arguing, you're giving an offer.
Milords, counter is not yet on record. I'm carrying copies.
Therefore,
Yes.
let there be clarity that
Yes.
we are now discussing only the counter offer. Correct?
Yes.
Sorry.
For 3 years, my counter offer is very simplistic in these lines. 2011, we filed an eviction petition. I have 2 sons. They are dependent on me vis-a-vis the rental that I get. 3 years next, for my bona fide need, I will use this premises. I will not give it on rent at all to anybody.
We offered them any other premises. They did not accept earlier. Now they've come around and said some other, but we can only give a floor upper, whichever is available with us. Right now, we don't have that availability. To justify my bona fide need, I will not give it. I'm giving an undertaking for 3 to 4 years. I will not give it on rent. I will use it personally. This is the maximum offer I can give, my lords.
He can't put any fetters on your enjoyment of the property unless the statute mandates that. But what is the offer which you have given him?
My lords, we had requested him, he can take any of the upper floors or any of the other alternatives that are available. We don't have a ground floor. He doesn't want any other floor. I only have first floor. This is the one with him is about 4,000 square feet, N18. This is on page 50.
On the ground?
Yes. Huh? Yes, ground and mezzanine, located on the outer circle.
This one, 4,000 square feet carpet area.
Yes.
You presume he has.
4781 square feet.
Whichever way.
Right.
So the area on the first floor is how much which you are offering?
My lords, first floor, second floor. We don't have any of the other that are vacant. We had a garage that was sealed because that is what he has.
There is no space.
Concrete space I cannot today. We had offered him at that point in time today.
Today there is no space.
No,
correct?
no, which is also the space.
Of money.
Yes.
Correct? Now what is that you wish to offer it?
I have nothing to offer. 2011 I filed an offer. Right, we made that offer earlier.
And there is no offer today.
I can give an undertaking. Yes, absolutely. Today, as someone who's seeking eviction of a premises since 2011.
1 minute. Today there is no offer.
My offer is my undertaking that I will use it. Yes, counter offer. No, I don't have one. We don't have one, unfortunately. There was a garage, but that's been sealed by NDMC.
There is no mediation, talks of mediation. Right? The counter stands already filed.
Already filed yesterday.
Joined within how much time?
1 week.
It will come after occasion.
Whenever your lordship.
No difficulty, lordship.
List on.
Then for time maybe.
May lords may return a date.
Oh, certainly we again. Okay, you do one thing. Open a diary.
Yes.
What date do you want?
16th July is okay with.
Very good.
Great.
So grateful.
No, my time may be extended than 2 weeks instead of 1 week.
No problem. No, we have said 4 weeks.
4 weeks.
Said 4 weeks.
Lordship has
That
done.
friend has prepared it so meticulously, I will not require time.
I am grateful and obliged.
Lordship, as per Lordship appear for the petitioner. Lordship in
Well, this matter I have opinion on the respondent file Vakatnama on
1 minute.
On Monday morning.
Yes, ma'am.
Lordship appear for the petitioner. Lordship, we have complied with the last directions. Lordship was pleased
Last order, they have to place and record the proceeding from the 60th as the paragraph.
You file your counter.
No, madam.
File your counter. You supply the application to him.
Lordship. Lordship, I am also seeking a Lordship if the operation of the impugned order may be Lordship stayed till the next date of hearing as well. Lordship was pleased to grant that those directions on the last.
Have you seen para 7 of our last
Yes,
order?
yes, ma'am.
Then I should say that. Learned counsel for the petitioner undertakes to supply complete paperwork to the learned counsel for the respondent during the course of the day. Counter for weeks is under 4 weeks.
Please, Mallards. In this, we have recently been engaged, Mallards. We have received the NOC. I request your lordships one this time. I'll file my wakalat on record. And Opening week, my lords, I will assist your lordship.
Lordship, since I appear for the Lordship, the Legal Aid Counsel, Mr. Abhishek Sharma, since the new advocate has not yet filed wakalat, so I am marking an appearance on behalf of Mr. Abhishek. And Lordship seeking withdrawal from the case because Your Lordship, the clients have engaged the new counsel.
Which case?
Lordship
Item
39, Your Lordship.
You are appearing for the petitioner?
Yes, Your Lordship.
Okay. Who's the
My lords, Narang Gagan Jaswinder Singh is the new AR in this.
Just give it in writing.
Yes, my lords, I'll give it.
As the petitioner has now engaged counsel of her. These are her words. As such, so and so undertakes to file power of attorney. Then, in this way of the matter, this Abhishek Sharma, correct?
Mr. Abhishek Sharma, yes.
Mr. Abhishek Sharma, Legal Aid Counsel, is discharged and is discharged. Then, counter.
I will file within.
Counter, we filed within 4 weeks.
I'm grateful.
Please.
Much obliged.
Can we not refer to mediation?
Mediation is already failed.
No.
The earlier one.
Earlier. So, can we not refer to mediation? It's a 3-year-old child.
No problem. Even, my lord, some of the matters has been taken through mediation, circulated over the Supreme Court. So we can consider it on that list also.
Mediation, Supreme Court mediation.
Please. Yes.
40.
Yes.
Mediation is failed.
Mediation is failed.
The only issue is of money. They are not willing to do it.
Yes, sir.
Mediation could not work, Your Lordship. That is what I mean.
Then, Mr. Harshit, what do we do? We'll transfer it.
We asked for 35 lakhs only, and except along with Sridhar, but they are not willing.
Actually, Your Lordship, the position is that the financial condition of the respondent is not so good these days because he had incurred severe expenditure owing to.
You're the husband, huh?
Yes.
When did the wedding take place?
2018, Your Lordships.
Any children?
No, Your Lordship.
Now you are getting liberty today, but whatever cost, he's asking for 35. Seconds have sorted out. We'll pass it over. Both of
We
you.
are ready to take 25 lakhs along with Sridhar also, but they are not.
Gentlemen, both of you, we are passing it over. Sit and sort.
Much obliged.
Come to a figure. Come back with a figure and a smiling face. Both of them.
We'll ask the parties to join. They can.
You ask the parties on phone, na?
Yes. We will ask to join through VCL. We will ask them to join through VCL.
They will also join through VC.
Not required.
First you settle up, then only.
We will ask for a figure by us.
Is this your personal brief or someone else?
My senior's people.
Where is the senior?
He's not in court today.
Tell him the court has decided and we'll sort it out.
Much obliged.
Today only it will be sorted out.
Much obliged.
I think 41.
Ma'am,
mediation is failed.
I am for the respondent, my lord. This is the my respondent is the mother-in-law, my lord. Respondent is mother-in-law. Filed the my lord DB petition. This petition now the petitioner seeking transfer of this petition, my lord, without making party to the husband also, my lord. And my lord, respondent mother-in-law is the 56-year-old, my lord. She has filed the petition, DB petition in Chandigarh court, my lord.
Mother-in-law had filed or daughter-in-law?
Mother-in-law has filed, my lord. She seeking transfer of the.
1 minute. Mother-in-law and husband both had filed or only mother-in-law?
Only mother-in-law filed the petition.
Item 42.
My lord.
We
My
have
lord.
dismissed it.
My lord.
We have dismissed it, sir.
Please, my lord. I love this.
Please, Your Lord. First, service has been effected on the state council.
service has been effected on the respondent, state of the art. And the affidavit or the translated copy of PW9, the clerk of the lawyer who has proved the post-mortem report, has also been placed on record. It was in Hindi, I got it translated and placed it on record.
Lordship, we had moved a letter because we're seeking time to file a counter and the records have been received by us.
Counter 4 weeks.
Since 2010, I am in custody.
1 minute, just 1 minute. Leave grant, hearing expedited, Calico record usual order.
Lordship, records have been
received as per your last order.
Again, list for hearing on put it.
I'm so grateful.
Record already stands received. Please supply digital copy supplied on Monday.
Item 43.
R1 in this case still stands, the service stands incomplete. We're praying for some more time for taking fresh steps. The registry is also tried through the SP.
Why did the High Court caution proceedings?
Lots of my instructions were just to request time for fresh steps and to get the sole accused here in the court first.
Okay, let fresh steps happen. Let fresh steps answer. Put it.
Item 44.
Lord, I appear for the petitioner. Your Lordships were pleased to issue notice and call for the original records. Lords, I inquired with the registry. It is not yet come, Lords, and I believe the state has not entered appearance as yet. It's a conviction under PC Act, my lord.
State who there?
My lords had directed in the last order. Harshad Hamid, Mr. Harshad Hamid, your lordships had in the order says that he accepted notice, my lord.
He has to be here. We are just passing it over.
Very well, my lord.
45.
Also, it should notice in given a short date is to see what the respondent has to say and what the service has been done on the respondent. The respondent has not entered appearance. This is a case where from 2015.
1 minute.
Yes.
As per office report, respondents.
I'm requesting for a stay of the judgment. I'm requesting for a stay of the High Court's judgment. The reason being that from 2015 I was getting maintenance. The arrears are now in upwards of 2.5 lakhs. And now because of the order of the High Court, everything is washed away. Only on the limited ground that I was staying in Akola and I did not provide any residence, but that residence details are all here, page 150.
You're the wife and the daughter.
Wife and the daughter. My passport, Aadhaar, all mentions the new address.
Then recently enrolled. Recently enrolled. 25. 25. Anyone in 26? Comes to the court with enrolled in 2026 would be account. Anyone there 2026?
My office was involved in 2026. I made the test her day.
In the court.
She's in the court.
Where is she?
Not this court.
There is one.
Come, yes, come forward. We have not appointed you earlier. We have not appointed you earlier. Okay. You are working with whom?
Yogeshwaran, sir. PV Yogeshwaran.
Sorry.
PV Yogeshwaran. AOR.
Just talk to your senior. Our order says you have to spend money from your own pocket. Send a letter. You have to take some action.
Wait for me.
46.
Hey, please.
Lords, I'm for the opponent. They circulated a letter seeking an. I'm for the respondent, my lords. They circulated a letter seeking an accommodation allowance.
I have a deal.
Sir,
Item 47.
Mediation is still pending, my lords.
Pending.
Pending. My lords, one request, my lords. The office report, it says that petitioners has not taken steps. My learned friend is already appearing for all the respondents.
LRs may be implemented. LRs of the.
They have been already.
One may be implemented.
The LRs of the deceased respondent already stand in pleading and are represented to the very same counsel who was appearing for the deceased respondent. And such office may make necessary correction in the office report. Then mediation is in progress. Report is awaited. Based on that.
Item 48.
Please, Lord. Well, in this application, your lordships had directed GDA. My lord, it's a dispute between the sister, my lord, and the children now of the brother. There was a land acquisition matter in which parties had come to this court for enhancement. The money, my lord, your lordship, the brother then.
Only just one.
Yes.
Can you see IA 150461?
Please.
They say that no amount is pending with the authority.
My lord, because they have already disbursed it. That was the difficulty.
Therefore, now there is no amount pending with any authority.
Please, no, there's about 45 lakhs which remains, my lord.
No, they say no amount pending.
Yeah, about 10%.
Let me be clear on facts. I'll make it.
You're the authority.
No, I'm not for the
Your
authority.
Lordship, I am appearing on behalf of authority.
No, we want to know any amount because the line deposited before any authority or no?
No, that
No,
has
Your
been
Lordship, it is not pending before us.
They are not pending before them. It is 30-31 proceedings have already been initiated.
Oh, I see.
Yes, so there, so that amount may.
That's.
But my lord, what has happened actually is that without disclosing to your lordships on the date when the order
Right
was
now,
passed,
today
about 3. So what we are praying, my lord, is that about 3.5 crores, my lord, was already withdrawn by them.
Correct.
Let it be deposited, my lord, in the trial court where the proceedings are now pending, my lord. Or, my lord, before your lordships.
What is the impugned order?
My lord, there was an order of 25th of September 2023. That's A14 of my application.
Page 103.
Page
103.
Please. Now, my lord, both parties were represented on that date. And if my lord see on page 104, as the proceedings before the civil court will determine.
Just one.
I'm sorry.
The money is lying with you.
Yes.
No, money was with GDA.
Today, where is the money?
Money is with GDA. GDA has already deposited the 30.
Entire amount.
That entire amount. That amount which has been directed by this court.
No, the entire 4 crores, the entire amount which was given as compensation or the amount which
Please,
remains
are you clear that 4
That's
crore
the
is not.
distinction.
Please.
Your Lordship.
4 crore is not mine. There are other co-sharers. May give the GDA's affidavit.
Co-sharers who are partying before us.
Not before us. That before Lordship, absolutely. Just tell it.
1 minute, gentlemen. Sir, kindly come to page 104.
Lordship, we are informed that land acquisition proceeding
has the proceeding before the civil court will determine the rights and of the litigating party.
Lordship,
We litigating parties are all parties or shareholders before this court or no?
She has, yes, of course, they have
All of them.
all of them, all of them.
We deem it appropriate to say that the learned civil judge will decide the suit on merits.
Gotcha.
To inform that the land acquisition compensation buying a deposit for the GTA as agreed to, the said amount may not be dispersed during the pendency of the suit. The money lying in the deposit may be invested in interest-bearing fixed deposit. But this order is made subject to the outcome of the final order of the pending civil suit.
Lordship.
Now, the intent is very clear that wherever, whatever money is lying has to be invested in the FDR.
Lordship.
Now, if money has been withdrawn by any one of the co-sharers, co-owner,
Lordship.
it has to be reinvested in the FDR and deposited in the suit. Title suit. Simple as that.
May I come to page 5 of the counter affidavit filed by GDA?
GDA counter affidavit page.
Internal page 5.
Dated counter affidavit dated.
Filed in a
If counter affidavit is dated. This is 24th January 25.
Are you appearing for all the private respondents?
Not all, no, not all. Only her. There are other uncles also. There, and one of the uncle has expired.
This dispute is between the brother and sister interstate.
That's all.
all.
Has he withdrawn any amount?
Yes, my lord. That's
No.
the point. Yes.
No, that's
You tell us how he has withdrawn.
please.
No,
Why unnecessarily burden us?
Precisely.
3.5.
31 is pending.
एक मिनट आप बैठ
Lordship,
जाइए.
lordship.
You please tell us that this gentleman who is before us,
My lord.
only one of him
My lord.
before us,
My lord.
has withdrawn the amount. How do
My
you-
lord. My lord. He himself, my lord, says, if my lord sees his reply, my lord, para 10 of his reply.
Reply means where?
My reply in this application, my lord. Reply affidavit of 8th May.
What on behalf of
Just read.
problem here is that
No, reply along with affidavit on behalf of legal representative Shaurya Garg, son of late Sanjeev Garg.
yes.
Now, my lord, here in reply to my application,
What does he say?
he says that the amount stands withdrawn
Where?
in response to para 2.5, a woman's made by the applicant so and so. The said amount, page 6, my lord, para 10. In response to para 2.5, my lord, has it? Okay, no. My lord, he says the said amount was released by so and so. It's being released to him. And he's saying that at that time they were in compliance with law. When it came, my lord, before your lordships in 2025, on that
Okay, have you received the amount?
2020.
May I put the facts clear? Put the facts clear. This is related to 3 villages. One village is in 2014, and it was on the basis of an affidavit which she filed before GDA on behalf of all, and GDA has filed that affidavit 17. It is with her consent, because at that time we were in good terms. She and mother both said, "Hey, please let one be withdrawn, and that should be dispersed amongst them." That would be because I withdraw, not in place of 3. In 2015, in 2021, she became wiser. And she filed a suit for partition and alleging that everything is joint.
Okay, now you want it. You furnish transparency. That's the end of the
Great.
Well, whatever the amount which I have deposited, the amount which I have withdrawn, the amount which I not the all one.
Obviously,
No, obviously that is
Related to
what is your name?
Madam J.M. Sharma.
His name is J.M. Sharma. No, the client's name.
Client's name. Oh, sorry. Sorry. I'm so sorry.
Sanjeev Garg is the legal heir.
Sanjeev Garg.
Sanjeev Garg. Or Shaurya Garg.
Madam, may I
Shaurya Garg. Shaurya Garg is the son. my lord.
I say one more thing. One more thing. They have moved an application before the trial court where there is an adjudication. This question will be determined. This question, she has already moved an application before trial court for the same relief. May I just say, this is that. I just.
If you have already moved, then why?
No, my
Yes,
lord.
precisely.
My lord,
In the
that,
same
that
place.
application, my lord, will receive a quietus. This was
Let's-
already filed.
No, because
That-
you are taking advantage of Supreme Court. This is page 35 of my affidavit.
Mr. Sharma, and then instructions from Shri Shaurya Garg, son of late Shri Sanjeev Garg, submits that
Page 35, there is an
the applicant, that the non-applicant shall furnish a bank guarantee before the trial court in relation to the amount so received by Shri Sanjeev Garg. Subject matter of the civil suit pending before the civil court.
I just request one more thing. Let it be a quietus, because this is an application being moved in an application already disposed of appeal.
So-
Let should be this disposed. Let should the suit be disposed of. Finally, it should be agreed.
1 minute.
Let
There could be in terms of and compliance of this would meet the
Because they keep
directions issued. In a consider this would meet the directions issued by this court with the order dated 25th of September 2023, passed and so. I mean, page 103. Page. What's up? Considering that the dispute, where is the civil suit?
pending before Ghaziabad.
No, plain.
This is Senior Division FTC Ghaziabad.
That, my lord, concerns my share, my lord.
We are
over
only asking where is the civil suit.
in
ma'am.
Ghaziabad, my lord.
Can you show the plain?
Yes, my lord. Just
Is it page 66?
E5 of my application.
There are how many suits pending intercity parties?
My lord,
No, only one.
my instructions
No,
are
only
that this
one.
is the one suit.
Only the one, my lord.
One suit between these parties, but there is another suit between the uncles and her uncle and my grandfathers.
We are only concerned with
So this present suit between the
where is that plain we were asking, sir?
Lordship share plain. Page. Plaint is not there, only in the application I have filed it, which she is pending.
Can you give us the suit number?
Suit number is 782 of 2021.
Yes, 72 of 21.
And the acquisitions pertain to the year 2000?
21. 782.
No, acquisition.
Acquisition is of 1988.
Considering the fact that the acquisition proceedings pertain to the year 1988, in relation to which two civil suits stands filed by the parties. One of them being civil suit number 782 of 2021. Titled, let's just give it particular.
Yes.
Shikha Agarwal versus Sanjeev Agarwal deceased. 36.
We direct
Sanjeev Garg.
Sanjeev Garg.
we direct the trial court to positively decide the latter suit within a period of 1 year from today. Parties undertake to fully cooperate and not take any unnecessary adjournment.
No.
All applications stands at this point.
My lord,
Little
let
ignorance.
my, because they moved an
What do you
application.
want?
I just want, Lordship has said bank guarantee. Lordship, allow me just give an option, bank guarantee or a property guarantee. Because
Guarantee or
property guarantee. Guarantee by property. Because may not be, because bank guarantee I have to deposit money.
the property?
My lord, the amount is reflected at page.
Whatever it may be, we are not concerned.
Deeply
All applications are listed.
I'm great. I'm great.
We just be back in 5 minutes.
Great.
59, let's report. Apologize. Because of the holiday that suddenly came, this matter has been advanced by a day. This matter was otherwise supposed to be tomorrow. It's been advanced by a day.
in view of this.
So what do you want?
No, sir, if your lordships could have it during the vacation, because your lordships recall this was being settled. Those terms could not be signed. Your lordships are sitting next week.
If your lordships will consider
Come up next week,
Wednesday
or
that's
Thursday.
convenient to your lordship.
We don't know what the sitting roster is. Of course, this bench is there all the week.
Yes, yes.
Are we sitting on all days? Yes, keeps up with our bench.
Next week, Thursday.
We learn Wednesday.
Wednesday, very.
As jointly paid.
Obliged.
We've circulated a letter in this matter. We request 4 weeks time to file a counter affidavit.
Further opportunity, English, counter, agenda.
Grateful.
July.
Item 51.
Your Lordship,
We have filed a counter appearing on behalf of R3.
I am appearing for the petitioner, but I have received the counter of respondent number 3. But my lord, I have not received the counter of respondent number 2. If they don't wish to file, my lord, I will file
I'm
rejoinder.
taking some time to file a counter affidavit. Representing Nagar Nigam Bhopal, R2.
Who are you?
Your Lordship, Nagar Nigam Bhopal. I'm seeking some time to file a counter affidavit.
And I'll seek 2 weeks thereafter to file rejoinder, my lord. I am for the petitioner.
Just one.
Yes, my lord.
We had appointed an amicus. What is your good name?
Sonakshi.
You had a very exhaustive report. Who has guided you?
Manoj, I generally sought help from my mother. From my mother. Manoj.
She's bad practicing.
She is a judge.
Fair enough. Oh, we were only wondering whether AI has been used or not. We must compliment you. Very excellent report, which is.
Thank you.
RI, real intelligence. Real intelligence. We fully appreciate the submission submitted by the amicus.
My lord, we may be provided a copy. R3 insurance company, we may be provided a copy from the amicus what she has submitted, my lord.
No problem. We appreciate the efforts put in. Thus far, when the respondent is now duly represented. All of them.
Your Lordship, R2.
One is not represented.
I'm representing R2, Your Lordship, Nagar Nigam Bhopal.
But R2 and R3 appear to be represented. R1, I think, is not represented.
R1 is still not.
R1 is still not represented.
He had requested you.
Manoj, I contacted R1, but
R1.
yes, Manoj, but
When let respond number 2 and 3 file their counter affidavit within 4 weeks, which are under 2 weeks. So such of those respondents, they have not filed. Really done a very good job.
thank you.
Deeply obliged. Deeply obliged.
Made clear, Your Lordship.
Mediation failed.
Yeah, mediation failed. But I wish Your Lordship to see the order, passed by Your Lordship, in which, Your Lordships have observed certain things. Kindly have a look at 4th November 2025 order. It is the SLP arising of the order granting one-time settlement to me and challenged by my friend's client, the husband. 4th of November 2025. Kindly have a look at the office report.
Yes, I have the order minutes.
What do you want?
So please have a look at it.
SLP was dismissed, minutes.
SLP was
Filed by
dismissed
the husband
with certain observation.
Yeah.
Please have a look at it. Para 3.
Though we are not
Yes. Mentioning the wrong act of the woman in the horoscope amounts to mental cruelty. That is the ground on which the marriage has been dissolved. Yet, as the matter in challenge before us at the present proceedings only in regard to award of permanent alimony of 20 lakhs to the respondent wife, the present petition is dismissed. So, his petition is dismissed with these observations that the only ground on which the marriage is dissolved.
What do you want?
Now, Milord, there are two things. One, Milord, I had challenged on merits. Two, at least, Milord, because we tried in the mediation, she wanted to go with him, he is not willing to take her. Now, Milord, let him also file an affidavit of his assets and of all his income in terms of Rajneesh versus Nia. We will also file, Milord, our assets, whatever we have, and the income which he has.
No.
So that
Just in these proceedings, are you not challenging the decree of divorce?
we are.
You are.
We are.
You are the husband?
Yes, minutes. Lordships may just see the
We are only asking.
Yes,
you.
minutes. Yes.
Have you remarried?
No, minutes. I'm retired. I'm 61 years old, madam.
We don't know.
No, minutes. Not remarried. Not
Do you intend to remarry?
No, 60.
We don't know why it is.
No, minutes. No, minutes. No such.
No problem.
Accepted.
Mediation is failed. Leave granted. Interim orders. Operation being of the state.
May.
That's
it. Your lordships have issued notice. Lordships may issue notice only for settlement, my lord.
We are extending. We can always open it up.
Hello, sir. I may be permitted to file a counter of 2 pages, my lord. Just
Yeah,
to
yeah.
I've been retired. I'm not in service. I've retired, my lord. We lived for 1 year, my lord, in 2010. From 2010 to 2011, we were.
You're not saying anything.
Yeah, at least
have you remarried?
No, sir. I have not remarried. No intention of remarrying.
Hearing expedited. We listed in the month of September. No problem.
Very well.
Let him pay the money, Milord. The money at least, Milord.
You got the moon, you are asking now what?
Very good. Very good. But you should take her back now.
My friend got the
I'm so glad.
High Court order stayed and he wants money.
I'm so glad.
Mr. Lordship, you circulated a letter in item 53.
How many times you will circulate?
Your Lordships, in fact, the counter was filed on 25th of May.
Not the counter.
Your Lordship, I filed the counter.
Not the counter, sir.
Your Lordships, we want to file a rejoinder. Your Lordships may kindly grant 4 weeks for the same.
Your Lordship, they didn't qualify the 2-year entity course. That's why he's ineligible.
Your Lordships, the controversy in the present case is very simple.
All other candidates have already been joined. He is not joined because of the entity course. He is not.
Your Lordships has made my selection subject to the outcome of the SLP. There's no interim.
Complete your instruction.
My lord, respondent number 7 is not. Lord, I am appearing for respondent number 3. Respondent number 7 has not yet been served, my lords.
Complete your instruction.
Lord, I am appearing for respondent number 10.
Pass over, my lords. 54, my lords. SG will come, my lord.
54 pass over.
55.
Lord, this is that Tamil medium study. Right? I'm from state. The judgment is correct. The judgment is correct. I'm not arguing on that at all. Your Lordships had perhaps given an opportunity to find out about the supernumerary post. So for that, Willards, I'm seeking a little more time only for this reason that the advocate on record has submitted a resignation because of the changes. If it is taken up in the reopening, Willards, pardon, Willard?
You're protected.
No, there's no protection. What is the protection?
No,
Single
some,
judge.
some post superannuation group.
That's the direction also of the High Court. Not the learned single judge.
It'll be.
Yes.
What is being said by the learned
Yes,
single counsel is because we change in the AOR.
No, that I understand.
It will be done.
Change in the government, it has to apply its mind. All that I'm saying is the single judge had directed that you take him in.
We are executing the judgment.
So therefore, they should do that.
This is a lame duck situation where the advocate on record can't take responsibility. It's a new government. Give it a little time. Have it in July. That's all.
Very well. Your Lordship may have it on due. That's very great. Great. Your Lordship may record my faint submission on this at least, so that next day
That I am lame duck. That I am lame duck.
No. To say that the state is accepting the judgment.
No. That's exactly what I shouldn't say. That's exactly what I shouldn't say on record.
Very good. Grateful.
Yes, we have complied with the direction.
Just. I'm service waited. Proof of service is not being filed, sir.
That amount is already deposited with her, but.
No, but service is. Proof of, you take fresh service?
Yes.
Fresh, dusty, then we middle of.
Item 57.
Hearing for respondent state in item
Hey,
57.
Lord, in this case, Lord, should we consider two FIRs were registered by the police on the same day alleging the same thing against the same accused. Now, both FIRs in the charge sheet, every accused person has already been acquitted. The only allegation against my client, as far as the FIR for which he is still inside, was that the main accused was doing online betting and he was one of the customers. Now, the main accused itself has been acquitted and it's been found that no proof has been adduced to suggest that he was doing online betting. So I'm praying Lordship may kindly.
Your Lordship, there are 5 criminal antecedents against
All
him.
are-
He
all
has
are
been
like
absconding
155.
in the main accused. There were arrest warrants issued, permanent arrest warrant. Then he was arrested from Kolkata, Your Lordship, and he cannot seek parity because throughout the trial only proceeded with respect to the 3 accused because he was absconding. The judicial magistrate has categorically recorded in his order that his period of custody was limited.
Below the entire. I'm good.
That's all, ma'am.
Yes, Your Lordships.
We are inclined. Thank you.
Very grateful to you.
Grateful, Your Lordships.
Your Lordship, I am appearing for the petitioner.
Yes, Lordship.
Bail.
Obliged.
These are those.
Lordship, we have filed one comprehensive list, Your Lordship. Sorry. The copy to them, we are just handing it over.
No.
Is a 6 categories, Your Lordship, in which all the names which were supplied to us have been demarcated, Your Lordship. May I just take you to this list, Your Lordship, because it will clarify everything, Your Lordship. So the first list, Your Lordship, if you'll have page number 3 of that compilation, that we are calling list 1. This list has been verified with respect to the petitioner in SLP before this Honorable Court in SLP 1359. Page 3, Your Lordship, which is list, sorry, that is page 1. Actually, I was going by
So
the PDF page.
292 are before this court.
Yes, Your Lordship. So, no, 232.
232.
If they, let me take you through this entire list, Your Lordship.
So, gentlemen.
Okay, Lordship.
List
Brief
one-
overview.
Just one minute. List 1, page 1 to 12.
232.
Huh?
232 names.
If Your Lordship can.
One.
Yes, Your Lordship.
List 1.
232.
No. You have the index with you.
Lordship, the 292 is the total. Out of that, many have actually withdrawn. So the effective number is 232. If you will have on the bottom of page 12.
We have seen.
Yes, Your Lordship. Yes, Your Lordship.
That is what we are saying.
Yes, Your Lordship.
Effective is 232.
232.
Correct.
After deducting those who have withdrawn themselves.
Very well.
Yes, Your Lordship.
So now this, what is list 2?
Now, list 2, Your Lordship, is those people. The list has been verified and has been found that candidate mentioned in it were not parties in either of the either writ petition against whom the SLP is here. Further, this list is not part of the record of this these SLP. So these are the people who had filed their writ petition before High Court. Against that High Court, they are not here in SLP. Your Lordship.
They are, please, Mr. Chaudhary, will you just please,
I am
do one thing, Mr. Chaudhary. We will say recuse. We are telling you, please, if one of you to the kindly request you.
We apologize.
Please don't do that. Sorry. It's only trying to understand.
Lordship.
So, list 1 are those who were before this court. 1.
Lordship.
Who were, we are using the word were and are.
Are.
List 2 are those who are before the High Court.
High Court.
Correct.
And not part of these 5 SLP, which is.
They are only before the High Court.
Okay. The number of these people, Your Lordship, is 130.
Correct. Correct.
Now the list 3, Your Lordship.
So list 1 is 232. List 2 number is
130, Your Lordship.
130. Okay. Now list 3.
List 3, Your Lordship, are the Mr. Amit Pawan's writ petition, Amit Pawan's petition, which, Your Lordship, where they have challenged the legality of the advertisement, Your Lordship. These are total 252 people, Your Lordship. So this list is from page 23 to page 105.
No, we have not understood. Challenge the legality means what?
They have challenged the advertisement itself, Your Lordship, and they were part of a different petition here, which was pending before another court, Your Lordship. They came here saying that we are also the same people, and they have joined here. Frankly, their relief is entirely different. They have challenged the ultra virus of the advertisement, Your Lordship.
Nonetheless, any which way.
And their SLP is still pending before this honorable court.
So
some other bench, Your Lordship, not before this court.
Very well.
These are 252 people.
252 are
yes,
those
yes, Your Lordship.
who are not before us in these matters, but nonetheless are before this court.
And there is one more thing, Your Lordship.
Home Guard.
Serial 199 to 247 of this list, they were not even party before High Court. They joined directly before the Supreme Court.
But they are not.
I'm just pointing out.
Very well.
Now comes the list number 4, Your Lordship.
Yes.
4, Your Lordship, are those applications who have filed their IA, Your Lordship, before your prohibitive order was passed, Your Lordship.
Okay. What is the date of the prohibitive order?
12th March 2026, Your Lordship. These numbers are 126. Although there is in the list there are 131 people, but 5 have filed
withdrawal application, deletion application, your lordship. So having deleted those 5, the total number is 126.
Very good.
Now these four category is 740 people.
What is list 5?
Now the list 5, your lordship, is those IA which are filed after the prohibition order, your lordship.
There are how many?
They are, your lordship, 63.
Only 63.
But your lordship, 63 once a prohibition order is. Your lordship, they are 60. Lordship.
What is list 6?
List 6, your lordship, they are nowhere, your lordship.
Nowhere means?
Means they are not party of any petition, your lordship.
But who has given this?
They have filed some writ petition which is pending.
See, how did you get this?
They have filed, because these are the names which they have supplied to us. That is how we went through them, your lordship, and verified them. They may have filed some writ petition which are pending somewhere, your lordship.
Some are defective.
And some of those writ petition are still defective, your lordship, maybe before the High Court. But these are the names which were supplied to us.
How many of them?
85, your lordship. But we have counted them as a 0.
85.
Yes, sir.
So let's put it like this.
Lordship.
745.
Lordship. Plus
63
is 803, or plus 85 is 888.
No. First, one by one.
740 plus 63. 740 plus 63 is 803.
Is it 740?
740.
My apologies.
Sorry.
740
plus 63 is 803.
803
plus 85 is 888.
plus 85 is
88.
88.
I took the liberty to do this calculation beforehand.
So you've done a great job. Undoubtedly commendable.
She did the major exercise, your lordship. I am just voicing it.
What is the total vacancies available?
Total vacancy, your lordship, 2471, your lordship.
2000?
No. 2380, your lordship, out of which 1168 is the women vacancy which cannot go to them. So the effective is 1212, your lordship.
1212. No, but suppose if amongst the 888 some are women,
then they will be covered by that, your lordship.
We have correctly understood,
Lordship,
that we are accommodating everyone, assuming hypothetically.
Lordship.
Then 740
Lordship.
plus 63
Lordship.
makes 803.
Lordship.
And those who were in the wings
Lordship.
had never ever been anywhere, but now today some list has been given to you.
Lordship.
85.
Lordship.
If we add all of them, then it comes 888. Right? Your total vacancy is 2380.
Less 1168 of the
Less 1168 is 1212.
women. Yes, your lordship.
Any which way, if assuming that all are male, they can still be accommodated.
I have one issue, your lordship. If there is a prohibition order by this court, your lordship, then those who have complied by this order, they should not be disadvantageous before those 63 who have actually went ahead and violated that order.
This one.
Lordship.
Prohibition order in what sense?
Let me see, your lordship. Let me show your lordship. Your lordship had said that henceforth nobody will file any application, and many people, they followed the order, your lordship. Those who followed the order cannot be lesser off than those who chose not to follow the order, your lordship. That is as a matter of majesty of this court, your lordship.
We fully appreciate and compliment you. The sincerity with which and the open-heartedness with which you are listening to us. In fact, we are obliged to you. What we want to say is this: for the time being, please ignore 63 and 85.
Okay, lordship.
Gentlemen, keep all of you, please don't speak. 63 and 85, we ignore. Now, what are the terms which you want us to?
Fitness test, your lordship. Because they are a police officials, your lordship. They will be
1 minute. One is the fitness test.
Lordship.
No, fitness test has to be given. One is the relaxation of age.
That's it.
One by one.
That's your lordship will take care of.
Relaxation of age. They have to undergo the fitness test. Now, fitness test, gentlemen, you also have to be, you have to keep factor the realities of.
Your Lordship, they are constables, Your Lordship. Suppose if tomorrow they are posted with some of the honorable judges over there only, Your Lordship.
But that was unexpected.
So they will say कि ये उसी की So fitness test is my only criteria. Age part you can take care of, Your Lordship.
These are the only two.
Yes, Your Lordship. Fitness.
One minute. One by one, we'll hear each one of you. But just be brief. Don't repeat. If you will allow, switch off this.
Just one last thing, Your Lordship. In the advertisement, Your Lordship, it is given all category of home guard would get 5-year additional relaxation in maximum age limit prescribed by the state government. So that is the part of the for the home guards, that is already the stipulation. I can give you the page number and all, Your Lordship.
The page number.
This is Annexure P1, page 36. In the Jitendra Kumar Sharma file, Your Lordship.
1 minute.
Jitendra Kumar Sharma file 1359, Annexure P1 at page 36.
वीडियो बंद कर दीजिए।
ये भी बड़ा जरूरी हो गया है।
Audio.
Item 60.
Please, my lords, I
Reserved for empty models.
Please, my lords. Item number 60, my lords.
Item number 60, my lords. Case of private university, age about 60, my lords.
Please, your lords. I am appearing on behalf of the insurance company, my lords.
Just 1 minute.
No party.
Please, my lords. I am appearing on behalf of the insurance company, my lords, in this.
Just pass. Insurance. Shriram Insurance.
Please, my lords. I am appearing on behalf of Shriram Insurance, my lords.
Yes, please.
Please, your lordship. My lords, if I may take your lordship to do page number 8, my lord, because the issue we have challenged are twin. Lord, one is the assessment of loss, that is the quantification of medical expenses. And secondly, your lordship, the contributory negligence, because it was a head-on collision with the truck insured by the insurance company and a Wagoner car wherein the injured respondent number 1 was traveling, my lords. My lord, these were the two issues, my lord, which we are raising. Lords,
How much of enhancement? Because we can, they are also here before us.
Alerts. Disability is 85%, alerts. He is a senior citizen aged about 86 years. Even still, the treatment is going on. Very good.
Counter notice to देना इसमें. Counter 4 weeks.
Please.
4 weeks.
Please, your lordship. I'll file. Okay.
Possible 4.
Yes, my lord. My lord, as per last order, my lord, I have joined the investigation. And counter affidavit.
My lord, I'm tendering my sincere apology, my lord. Please, my lords, may kindly hear me for a minute, my lord. I had been in some personal difficulty, extreme personal difficulty, very genuine difficulty, my lord. I'm just praying there is already an interim protection in favor of the petitioner, my lord. With folded hands. No, my lord. He is the main accused. 15 lakhs rupees has been recovered from his house, my lord.
No.
He is the main out of 19 lakhs. 15 lakhs recovered from his house. We have the seizure list, my lord. Number 2. My lord, please, my lord. Just only a week, sir. My lord shall have it in the next week, my lord. Please, my lord.
Next week.
I'm so good.
After vacation, it's possible, my lord.
अरे आपके हक की बात कर रहे हैं.
Obliged.
Honor for the next day.
I'm so good.
Obliged.
Wednesday.
Possible 19.
Wait, please.
Yes, please.
Well, as I was unable to connect with the arguing counsel, I had sought to pass over on that aspect itself, my lords. I'll endeavor to assist my lords in this.
Argue, please.
My lord. My lords, the crux of the case is that the claimant, the respondent, who is the claimant in the present case, has sought claim towards travel allowance from his parent place of residence to the place of duty where he was supposed to discharge the duty as a duty magistrate in the elections. Now, my lords, we seek to assail the impugned order on 4 grounds, my lords. First being, my lords, that an honorarium was already received.
Was he entitled for petrol or not?
My lords, this is a case where he is seeking travel allowance from his place of residence to. My lord, kindly.
Thank you.
My lords may kindly appreciate. My lords may at least.
We have heard. So, what's about name?
Brother. Rajasthan.
However, we are unable to pursue our services.
My lord,
The latest.
my lords, we kindly appreciate 2 grounds, my lord.
Thank you.
Very much. Deeply obliged.
But in 22, first, my lord, I must say, I'm not pressing, my lord, the order passed by the Tribunal of Reinstatement and Backwages. Only issue, my lord, I am urging before your lordships is based on the GR, the state policy enshrined, my lord, in 1978 GR.
There are no case, sir.
Lord, please have a look at page 38.
Sorry, sir.
That's the only thing. Lord, insofar as reinstatement and back wages against the employee, I am not pressing. Your lordship may record my statement. Lord, there is a state policy that if I have not appointed anybody in his place, then Lord, to the extent of that grant, Lord, I am entitled to, Lord, and that, Lord, that was what was urged. That High Court refused to, Lord, go into. As far as employee is concerned, for whom your lordships have a concern, and Lord, therefore I am making a statement. I am not challenging that.
How will this policy at page 38 apply?
Please see that, Lord.
You tell us.
Yes, Lord. The policy is, if an employee is removed from service and some appeal, etc., is pending, if no person is appointed in his place, which was a granted post, then to the extent that grant which was not availed by us, Lord, that can be paid, used towards that back wages.
Thank you.
Please. May I request one thing? Keep aside. May I request one thing? This was not really the main issue before the High Court.
So we have this put points.
The employee will be safe, Lord. He will not be affected by that.
Thank you.
Please.
My petition for divorce is rejected, but after 13 years, her petition for restitution is allowed.
Has been allowed.
That's last.
Only for settlement. Justice on merits.
I have no problem.
Only. Not inclined.
You have no option.
No, I want nothing left in the marriage. I am not
So
that's why we say
we are not inclined to interfere with the petition on merit, but however, for the purposes possible.
Because I just wanted to point out that the High Court seems to think there is a child out of the marriage. There is no child.
that's a mistake.
There's a mistake. There's no child out of the marriage.
All through there is nothing.
There was no child.
And it is submitted that no child from the wedlock was born.
Great. Otherwise, it goes before the mediator. They will ask what happens. I just wanted to clarify that. Great.
Yes, sir.
Please, my lord. I've been informed that recall application has been allowed. Today it was listed, my lord. Today itself it was listed. This is the last at the foot.
Then you go and argue that.
My lord, yes, my lord.
He submits that.
My lord, this is
the matter is we are expediting the hearing there.
Yes, ma'am.
That the petition, which was dismissed on 7th of May 2026, stands restored. In this way of the matter, we request the High Court to decide the matter.
My lord, every time they give the date pass, whatever it is going on, we have 10
Preferably within a period of 3 months. We direct the parties to appear to the High Court on. छुट्टियां कब खत्म हो रही हैं?
31st.
छुट्टियां वहाँ कब खत्म हो रही हैं?
वहाँ तो सर 30 जून तक चलेगा.
30 जून तक थी. Second week of 3 months from the date of appearance.
Please.
Password 30.
Yes, checks are handed over, my lord.
Checks have been handed
One check is remaining, that is of December 2026. But I have no objection, but he has not received it. But what my request is that the lordship may keep this contempt.
No, we will not keep it pending. We will give you liberty.
No, my lord, this is second contempt petition. What is poor lady is not being forced.
Why keep it? Why they keep the petition pending?
No, just kindly, my lord, he has given one check of June, second check of July. I am requesting to adjourn it to 20th July because for the second check is of 15th July.
What is the date of the last check?
Last check is December.
15th
20th December.
How many post-dated checks?
7 minutes.
7 post-dated checks and
6 have been handed
6
over.
have been
7
handed
needs to be handed over. That's
6
6
post-dated checks
For 52 lakhs minutes.
for a sum of rupees 52 lakhs stands handed over by the land counsel to the respondent to the land counsel, the petitioner.
Petitioner wife, handed over to the petitioner wife, counsel.
One more check
My lord, yes,
Of 10 lakhs.
of rupees 10 lakhs
I will get it by Friday.
is undertaken to be handed over within 1 week from today. Is this petition ENA 2027? What is the last date?
20th December 2026.
27 January. Actually, why keep this petition?
No, my lord, your lordship, my lord.
Just 1 minute. Petition is disposed of, reserving liberty to the petitioner to revive the same. Petition the MA, should the need so arise. Next.
Lord, that your lord was passed by your lordship on the last occasion, and this is second contempt petition, my lord.
We'll send him behind bars now.
This, if the check is dishonored, then my lord, that my lord, if your lordship keep it pending.
I have received the information that the law department has already received the speaking order, and the copy of it has been sent to the other party also, my lord. And as far as the speaking order is concerned, my lord, I was just reading because I have received the mail, my lord. As per that speaking order, they are not having the permission as far as B.Ed college is concerned. Other things are also there. If they are agreed, they can file the objection.
Permission is on record.
That's right. That's right. Therefore, I am saying speaking order has been passed. Copy has been served upon them also, my lord.
There is no service to us. Please don't say that.
Law department says they have received just now. In the sense, I have received the letter, my lord.
No problem. We'll adjourn it. We'll place it on record.
Yes, I will.
Let the respondent place on record the decision taken by the
competent authority. Yes, sir. Review of lives.
Can it be followed after reopening? Because then
after reopening.
Yes,
my lord, a
review
copy
of
be
lives.
given to us. my lord,
Yes, if they have not received, I will give the copy. No difficulty. First, I received that.
They will file an affidavit.
Yes, I will file
that will come only one day before the hearing.
No, I will file it within a week. I will file within a week.
Affidavit we file within 2 weeks.
Within 2 weeks.
Great.
Affidavit with the report one. I will send the report. Obliged, deeply obliged.
Grateful.
Passover 35.
Lordship, I appear in the item 35 Passover matter.
Yes.
Lord sir, I have instruction that matter should be listed after vacation because client doesn't have a specific amount in his mind. Let it be adjudicated. And the second thing is, Lordship, there is a child. So there is an issue regarding custody also, Lordship. So some time may be given, Lordship. It may be listed after vacation, Lordship.
Even though mediation is failed, but however, considering the attending facts and circumstances, we have to consider a view that we implore upon the parties to again explore the possibility of a mediated settlement. List on dash and the parties shall remain.
May I just point out one thing? May I just be allowed to make one submission, Manoj? Fellows, in terms of the interim maintenance that has been ordered, which is 20,000 rupees only, my lords will, for the time being, if my lords are keeping it pending, my lords, the date that he has himself agreed to is from April 2023. And my lords,
It goes without saying that the petitioner
from April 23.
comply with the orders passed by the post. Next case.
So grateful to Article 40. Then do my lords, then that will mean would wish to modify their the order that was passed, my lords, in February, because that
Said
specifically
something-
records. I would just to.
We'll see that on the next date of hearing. Rest.
I am in my lord's hands. I am in my lord's.
Yes.
Your Lordship, we tried contacting our client, but we could not connect with him. Your Lordship may keep it on any next date. I'll seek instructions.
Can it be on this week also?
Let parties remain present in court on Tuesday.
Article 44.
My lord, I contacted Mr. Hamid. He says that he has resigned. My lord's notice might have to go, my lords, again.
My lord, Arthur sir has resigned yesterday, my lord.
Resigned.
From another office of standing.
And yeah, request for adjournment is made on behalf of the state for the reason that there is change in the panel. There is likely to be change in the panel. Then
Article 54.
Right.
Because here Mr. Ahar appears, held up in another court. No problem. Friday also any other. The counter has been filed by the other side. The amount was directed to be deposited. That has been deposited by us. Around 29 lakhs has been deposited. This will have to be heard then.
Sorry.
Because 29 lakhs has been deposited by us. Therefore, it will have to be heard for this.
I have filed counter, my lord. And this is accident claim.
Can you file your rejoinder?
Please. Please.
Rejoinder within
4 weeks for this.
4 weeks.
Immediately afterwards.
Please come back. No problem. Miss
with the Lordship's kind permission. Mention a matter before just Karol. Just a matter in which a custody dispute where your Lordships had appointed Justice Ravi Kumar as the mediator in our custody dispute.
That is coming.
No, it's not. The problem is that child needed a behavioral pattern has changed, so we had applied to Justice Ravi Kumar for with Justice Masi. We are praying that we have moved an application because Justice Ravi Kumar said if at all there is a direction, then only we can appoint a child counselor. So now that we have moved an application for that, we are only praying it can come up on Friday with the consent of other side I mentioned. Very
Sorry. Unlisted mentioning, I don't entertain.
No, this is something urgent and Justice Ravi Kumar of the people that he can't pass that order unless your Lordship.
It's a matter of policy.
Yes.
Principle, I have never accepted an unlisted mention. Just accept.
Yes.
You inform the registrar. You inform the registrar to list it. Don't say anything.
And the very same combination is available in the first week also.
Yeah, we are open to that.
We are just letting you know.
It will be a pleasure to come even in the first week. It will be a pleasure to appear. Right.
May I have your Lordship's permission, my lords?
Yes. So.
My lord, item 301.
Yes.
Lord, this is a matter between employees and the state government, state of West Bengal. My lord, the Honorable Chief Minister of West Bengal is meeting the employees today, and we are hopeful that the problem will be sorted out.
On 38th.
On 30th, yeah, I'm sorry.
On the other hand, the solicitor is on his leg. Of course.
This is the meeting.
The same thing which you are informing on SG is also informing the same thing.
That we are meeting, my lord, within on 30th. If it is kept in July, my lord, it may be resolved, my lord. We are hopeful.
Then kindly fix it up, the opening week of the July, like the 13th or 14th. I think in the meantime some progress would make.
Okay.
Yeah, right.
Yes.
Your Lordship, this is the communication that has come to all the parties. Lordship, I had actually moved a letter also based on this.
No, everyone is agreeable, in short. We need not individually trouble the court.
Yes,
Well, Lords, we have one small thing.
Well, let it be first week of the opening, I think.
That the learned solicitor has come himself in this matter. So we are all extremely appreciative of that. And if it is all solved, my lords, of course, then there is nothing remains. My lords, with regard to the monitoring committee, though, we are just seeking that let all of this be resolved in any case, if at the either at the government stage or at the with the monitoring committee within a period of 3 months before Pujo, before Durga Puja. So just a timeline.
No problem.
So let it be in the month of July. Why?
Yes, for July.
Because in the meeting, the stakeholders can be heard.
Yes. And the learned SG is there. He'll call everyone.
I mean, let the association is, yes.
Learned Solicitor General informs that talks amongst all the stakeholders are in progress. Shall we say that are in progress?
My lords, not in progress yet. That have been invited.
Date is fixed for me.
My lord, date is fixed, my lord, for
the meeting has already been scheduled. That
gentlemen likely to take place in the near future, immediate future. As such, we adjourn the matter. Release on
Obligator.
My lords, could we possibly have a specific date?
We are giving a date.
Deeply obliged.
Subject.
Second week of July. Second week of July.
The status report comes before that, so we all know what has happened also.
Wednesday, 22nd, Wednesday, 2 p.m. 26th.
My lords, my lords, a status report
we would
prior to, so that we know what has happened,
Hello, whatever
so that
development
we
will
can,
be there,
it can be an effective hearing.
On record, madam.
State shall file status.
There's a review petition by the state that can be withdrawn or dismissed.
Sorry.
The state has filed a review petition also that can be withdrawn or dismissed.
Let them take it.
I see.
Probably it is only for withdrawing the review, they are convening the meeting.
Maybe.
Because we were the interveners, Millers. If we can make a representation on whatever points.
Everyone will be there. Thank you.
Obliged. So obliged.
Please, my lord.
Yeah, please, bro.
My lord, unclaimed protection has been granted by this honorable court. And my lord, I have joined to investigation. Your lordship, the co-accused, even Jekhani, she was living with together the deceased and granted bail by the Honorable High Court on 6th of January 2026, my lord. The matter is parity also.
Lord, there had been a loss of human life, my lord. And see the brutality, my lord. I will show from the counter, my lord. I have mentioned the
my
postmortem report, my lord. My lord,
my lord,
kindly see the brutality which they have done, my lord. Only because they have got the interim protection, my lord, it does not confer a right, my lord, that my lord should kindly see the counter affidavit for a minute, my lord. Two accused had been sent to judicial custody, my lord. Saraswati Devi, my lord, if my lord should kindly see page number 8, para Roman 4, my lord.
Who is the petitioner?
Petitioner is Sugandhi.
Petitioner is the sister-in-law of the deceased.
My lord, I would like to, in cognizance of this honorable court, my lord, before the marriage of deceased, I got married.
1 minute. Dilip Sharma is the husband.
Yes, my lord.
Is he on bail or inside?
My lord, he is in judicial custody, my lord.
Judicial custody. Putul Devi?
She is granted bail by the Honorable High Court of Patna. 6th of January 2026.
Dilip Sharma is the husband. He is inside.
Yes, my lord.
Saraswati Devi, sister-in-law,
yes, my lord,
is on bail. Correct? We are asking on process.
Yes, sir.
Then Sugandhi Devi, who is Sugandhi Devi?
Sugandhi Devi is the petitioner, my lord. She is before my lord's, my lord.
Okay. Geeta Devi?
Geeta Devi is also petitioner, my lord. She is before my lord's.
Saraswati Devi?
She is in judicial custody.
She is in judicial. So, Putli Devi, sister-in-law, the wife of the brother is in. यानी कि Jethani or Devrani is on bail, but the nuns are behind bars.
Yes, sir.
Behind bars will be dismissed, they will be behind bars. Now, we just want to know, they were all married.
Yes, my lord.
What is the allegation against? Direct allegation?
Yes, my lord. Number 1, they are named in the FIR, my lord. Number 2, my lord, there is a role attributed to the petitioner.
What is that role? Let us see.
Yes, my lord. If my lordship may kindly see page number 30, my lord.
2930 is the FIR.
Page number 30, my lord. 7th line from the top, my lord.
The demanded dowry of in cash and 1 bullet motorcycle where we had performed the marriage according to our capacity. These persons acting together did not provide sufficient proof to my sister. My sister used to inform me that all these matters are phone, and I have also gone to village Burai and convened a panchayat meeting regarding, but there was not even the slightest improvement. The conduct of the party Devi, Srimata Devi, Jeera Devi also used to assault my sister and subject her to civil cruelty, and used to instigate the Dilip Kumar for a second marriage on account of non-payment of dowry demand. So this is the allegation.
Yes, my lord. No, further, my lord, evidence and witnesses regarding this incident are available with me. Therefore, all these persons, Lord, this is very important. All these persons acting together on the same date stuffed cloth into my sister's mouth and strangulated her, and after killing her, hanged her from the ceiling fire. But this has come in the postmortem report also, my lord.
My lord, even the informant is not eyewitness, and when the incident occurred, my lord, I was far away. I was far away, my lord.
Have you examined any witness?
Yes, my lord. Against out of 6, my lord, out of 6 accused who are named in the FIR, against 2 charge sheets have been filed, my lord. Against 2 charge sheets have been filed. The husband already been filed. I mentioned in the counter affidavit, my lord.
Then Saraswati, okay.
My
What
lord,
about Sugandhi and
page number 9?
No, after the investigation, what is the specific? Because see, that is now it is beyond gone beyond FIR. We have done some investigation. We have examined some witnesses, neighbors, whatever it is. Any role specifically assigned to Sugandhi?
There are statement of witnesses, my lord.
Was that
That is not there on record. I have not placed my lord with the counter, my lord.
My lord is still now.
But if my lord wants,
Witness
my lord,
has
I
been
can place the
cross-examined.
statement of the witnesses, my lord, who has deposed against the Suganti Devi also, my lord.
Geeta Devi also?
Geeta Devi also, my lord.
Saraswati also?
Yes, my lord. That, on the basis of the statement of the witnesses, my lord, the charge sheet has been filed, my lord. And my lordship may kindly see the page number 9 of the counter, my lord. A very humble request, my lord. Kindly see page number 9 for a minute, my lord. Para number 5, my lord.
No, that we have seen. That therefore, is any what is the role played by them? That is what we are.
My lords may kindly see there is a ligature mark present around the
we
neck
have
of the
seen.
size.
That husband also can read himself. Question is, what is the role of these ladies, women?
My lords may kindly.
Has anybody seen? Anybody said anything?
Even in the post-mortem report, my lord, the cause of death is due to asphyxia caused by strangulation, my lord. Even in the post-mortem, my lord, it has come cloth particles inserted into the mouth, my lord. I'm so good.
My lord, I would like to raise some contention. My lord, even Jethani was living with the deceased person and she was granted bail on 6th of January 2022. My lord, before the deceased, before the marriage of deceased, the petitioner got married. And when the incident occurred place, my lord, I was far away. No any even informant is not eyewitness. No any direct evidence of your lordship.
When will you surrender? When will you surrender?
My lord, for 4 weeks time.
Surrender on or before. The petitioner shall be, as and when the petitioner's application for a grant of regular bail is filed, we are comfortable with the same. We trust and believe that the same shall be decided on execution. Yes.
So good, extremely good.
303.
The written submissions are what? We attempted a mediation, it didn't work out. In fact, we sent people to take pictures, photographs to work out if some division or partition is possible. But Akriti and I,
That's all right.
So Lordship, we have all of us have filed written submissions.
Yes. This is with regard to the inheritance of the.
Yes, my lords.
Right of the
Yes.
children.
Yes.
To inherit.
So there were yes, my lords. So therefore, only one thing is relevant is that if your lordships have my submissions, if you can just refer from that, it says submissions by my and filed by Akriti. Just have that.
Submissions filed by
me filed through Akriti.
Petitioners, correct?
This must be as a micus. Petitioner's advocate, I don't know.
And for the respondent 1, 2, and 3.
Petitioners have sold their property to Ms. Hingorani's client, so therefore lordships have.
Well, the submission says submission filed by Gaurav Agarwal, senior advocate.
Lordships have. Can I hand over? Can I file? 8 February to file. Yes, that's correct. Just if your lordships just have page 2 of the chart. This is the family tree. Page 2 minutes. Now this Matthias Anthony Milos had 2 wives. If I can say first wife or second wife, although second wife technically is an incorrect term. Philomena and Shambai. And the whole dispute relates to this document of 6/3/1959, which is a joint sale deed which is executed in the name of both the wives from the purchaser, third-party purchaser. This is the property in dispute. So the land in question, which is measuring 177 square feet, situated in Vilas, was purchased in the name of Philomena and Shama by both wives of Matthias by way of sale deed from so and so, and so the names are not relevant. Now what is contended is that if it is joint purchasers, both the branches, that is Philomena's branch and Shama Bai, will have half share with it. If your lordship recognize, yes, that it is a joint, it's a sale deed. The other view which has been taken is, if Mr. Matthias Anthony has purchased the properties in his name of two other wives, on his death, it will devolve as per his succession. Then, Milords, 1/4 share will go to the defendants and 3/4 share will come to the plaintiff.
No, say that again.
So, Milords, sorry, can I repeat, Milords? The lordships have this document with me along with that 6/3/1959 document. Milords, just have this document, which is part of the SLP paper book, Milords, page 23, 24. Lordship will just keep these two documents together, Milords. It's a very old document. We believe this is the correct translation because the original records are not here. This is one piece of land in Bilaspur, Milords. We actually requested somebody to take a drone footage, sat with both the parties to figure out, but there is no division possible. It's in the manner which we thought would be workable. So Lordship will have page 23. Lordship, just see here. Now this is the document. Philomena Bai and Shama Bai are both wives. Admittedly, is married to them both and had children from both, but of course, second marriage issue remains.
And they're tribals, Christians, or
they're Christians.
They're
Christians, yes.
Christians,
yes. The second marriage is not valid in Christian, so that other marriage is not surviving.
Therefore, the question arises.
Therefore, the question arises. Yes, Lordship's right.
So,
yes.
First wife is
Philomena.
Philomena.
Yes. They were the plaintiffs in this suit. Factually, it appears. We are trying to get drone footage. I'll show that from the top, but they're trees. Factually, it appears that parties are roughly in half and half. Parties are roughly in half and half. This is why our submission said that if this deed is construed as purchase of two equal shares by the two wives, then half and half share is equitable. And if it is considered as the property of the husband, then it will not go to the wife's share, second wife's share will not get, the second children will get only.
So,
yes,
what we have to now construe it.
Yes, Milords.
Examine it.
Yes, Milords.
Whether the property was purchased
yes.
jointly by two individuals.
Right, Milords.
Who were the wives of.
Yes, Milords. Matthias Anthony.
Or the property was purchased by the husband.
Yes.
This is it.
This is it. That's all.
If the husband.
Yes.
See, we are more interested in law.
Yes, Milords.
Based on the law.
Yes, Milords. Yes. Yes, Milords.
Right of inheritance amongst the Christians.
Right.
So, if we come to the conclusion that it was purchased by two individuals,
yes, Milords,
then the right of inheritance
is irrelevant. Yes,
irrelevant.
Irrelevant, Milords. Yes, correct, Milords. Absolutely right.
But if we come to the conclusion that it is a property purchased by a individual,
correct, Milords,
then the right of inheritance, as far as second wife is concerned,
yes,
is out of question.
Wife is out of the question. Children will.
Only the children will get it.
Children will get it.
Children will get it in what proportion?
So that also we have calculated. The trial court order it gives 3/4 to the plaintiff and 1/4 to the other children. But the plaintiff is the first wife and the defendants are the second wife. 3/4, 1/4. That is all in my submissions. I have put it.
Because she has got 3 children. There.
She has got yes.
The first.
Yes, that's right. So depends who died when. That will devolve like that. So we have put all this in our submissions with us. That there is no dispute on. Only question is this document. If your lordships,
we together have received a total of ₹300.
Since we have purchased the land as so and so, for this reason we are selling. These are the sellers. Sellers are irrelevant. Due to necessity of amount, we have given possession of the property written below to the purchaser from today itself. Now they took possession, make their names entry in Patwari document. Now we are not having any claim or title on it. It will not be the future. If person claims over it, it will be presumed false. If any part of the sold property is taken out from possession by us, there will be any loss to the purchaser, then we will be liable to pay damages. This property is not transferred to any person in any manner. Therefore, this sale deed is written down so that it may be used in time.
So what happened to this sale deed?
So the sale deed remains.
Stands.
This sale deed remains, my lords.
No, no. Purchaser is
The wives, 2 wives.
Samara and
No, so that was sellers, my lords. Samaru and Dhan are sellers.
and
Yes, my lords. Philomena and Shambai.
and the trial court framed the issue for the ownership.
Yes, my lords. The trial court says that this property actually was Matthias's property. It was purchased in the name of 2 wives.
That's the finding of fact.
That's a finding of trial court.
And the High Court?
High Court, Milos, actually has gone on a little different tangent. It has given much less share than the trial court.
On the finding.
Finding, the High Court has not disturbed that. Let me just check. Is the High Court on this finding, Milos?
No.
High Court has not.
The appellate court reversed it.
High Court,
Second appellate court has now again decided in my favor.
Yeah.
But with a different relief.
Different relief.
That's all right. But how has the trial court interpreted this document?
Yes, Milos.
The Indian Succession Act saying that it for divorce.
No. Whether it was jointly purchased or
It presumes it was Mattis's property.
one by one.
Sorry.
Trial court, what did the trial court hold was this particular document? Is it jointly purchased or is it the property of the
Mattis. Trial court
It's as simple as that.
Yes.
What is the trial court hold?
Mattis.
Mattis.
Yes, Milos.
What is the first appellate court hold?
Reverse and dismiss the suit.
Not Mattis.
Not Mattis. Joint.
But the High Court said it is Mattis.
Yes.
But different. Yes.
Mattis.
Yes. The shares have been wrongly given by the High Court. But Milos, on just one thing, and there is hardly any evidence either way. Because none of the parties are alive. At that point, it is a 59 document.
But suppose that this document will be read as it is.
Yes.
Then how can trial court come to the
Right, Milos. That is what we have said as amicus, our submissions is that apart from this document, if document is plain and simple for 2 wives, it is settled for 2 wives, is as amicus we thought was the correct approach which was adopted is our submission.
The document itself
Yes, Milos.
is still speaking.
Yes, Milos. That's all our submissions without prejudice, Milos. I didn't want to.
Be affected if we say that the document. What do you
1, 2, 3 more. So, Lords, only have. I will just show what were the pleadings on that side.
Forget about pleading.
No, Lords, they have admitted that it is Mattis's property. Yes, please, madam.
In the WS,
yes, I will show you
because he purchased but in the name of the 2 wives.
That's right. So
he is the actual financier.
No, he is the owner, Lords, as per the Benami Act. Please have page C of the SLP itself, and then only one
SLP trial court.
Lords, I will show what they have repeated in the SLP and the trial court. Please have the trial court, Lords, page 25, because the pleadings somehow are not there.
Pleading from the file.
Oh.
Sorry, actually, we got the trial court record much later. We have the record of the trial court also. Sorry, I didn't, since the mediation didn't work out. So, Lordship, Akriti, just read that. Akriti has just. We have tried to get as much as possible, Milos. The first document is the plain. 1 to 10 is the plaint, Milos. In Hindi. Plaint filed by Mr. Gagan, first branch. Philomena. Yes, Robert Anthony Philomena.
What does Philomena say?
The Philomena was dead by then. So the children say at page number 13, Lordship will have just 3 lines above para 2. इसका हिंदी भी दिखा दो एक सेकंड।
कोई बात नहीं, आप इंग्लिश पढ़ दीजिएगा।
Out of affection, he executed the sale deed of sale land in favor of his legally wedded wife Philomena and unwedded wife Shamabai. He carried out repairs of the house and also got the construction done. प्रेमवश, this is para page 2 में प्रेमवश उपरोक्त जमीन, हाँ same thing, this is the same.
And what is the WS?
I just show you. 1 second. Give me 1 minute because I have not marked this because this document had come little late to this. Just 1 second, minute. They say that we are both wives. Page 27. Philomena and Shamabai are both legally wedded wives of Matthias. John Matthias, husband of defendant, was son of so and so children. It is submitted on behalf of defendant. The Shamabai used to work in Bhilai and constructed the house. They have admitted para 1 because the governments in para 1 are admitted.
No, but can you come to page 22?
22.
Plaint relief.
Yes, Milos.
The property, why are they seeking the cancellation of?
No, that's a subsequent sale deed, Milords, in favor of my friend Ms. Hingorani's client.
Later on,
By-
it was sold to my client.
That's why the
That sale deed I am seeking.
So they have not, the sale deed is not, is not challenged, I mean, it was challenged later, but actually the property was devolved on both the wives. So the lady then sold it to Mariam Anthony, whose legal heirs I am representing in as respondent number 4.
There is subsequent purchase.
Yes, madam, from the other second wife. Right. So, Manoj, I don't see an issue on Benami, etc., or how the money came, etc. So, I'm not sure how the High Court says that it is Benami property and 1959 purchase. So, therefore, we.
Benami you have to show.
Yes, Manoj.
Benami law is very clear.
Yes, and that Benami Act came in 88 also.
This Benami issue has been also raised also.
But para 1 is a
No. Let us not go by inference. What is your pleading? Was there any pleading on Benami? No. Finding on Benami?
Now, what happens is, I will just read one line of para 1.
Let us not raise Benami in Supreme Court.
No, para 1, it is claimed that he was the owner, and para 1 of the written statement, it is admitted that he is the owner. So, no issue could have been raised. Please see para 1 of the plaint at page 12 with us, Lord. Of this compilation which the learned amicus has handed over, the English portion, page 12, bottom, my lord. I will quickly read the last word on page 12 and then onwards. The land bearing. Lordship Sahib, my lord. The land bearing Khasra number 690/7 at measured 0.04 decimal square feet owned by father of the plaintiffs is situated in village Juna Bilaspur and district Bilaspur and at Mohalla Tarbahar Indra Colony, the revenue court. Plaintiffs further, father had purchased this land with a sale deed of ₹300 from Samrao, son of Khorai, and his wife Hanbai, resident of so-and-so, in March 59 came into possession. Out of affection, he executed the sale deed of the said land in favor of his legally wedded wife Flomina Bai and unwedded wife Shama Bai. He carried out the repairs. Now please have, my lord, page 27, which is the written statement English. Para 1 starts by saying, my lord, it starts by saying, Lord, that the averments of para 1 of the plaint are admitted with the amendment that Shrimati Philomena Bai and Shama Bai were the legally wedded wives of Matter Anthony. John Anthony, the husband of D1, was the son of Shama Bai. D2 to 5 are the children of John Anthony. It is also submitted on behalf of defendants that Shama Bai used to work in Bhilai and she constructed the house on the land given to her by her husband on partition after she retired in 86. Rest of the averments are correct and denied and admitted. Since they did not dispute, lords, there could not have been an issue.
And what was the issue framed?
Yes, lord. For the issue, lord, lordship sees the main paper book.
It's 28.
It's 28. Yes.
Para 19, page
28 of the main paper book, lord. SLP paper book.
That's
28 lord, bottom of the page is para 6 by the learned trial court for proper disposal following issues. Whether the suit land being joint property of the plaintiffs and D126, the sale deed dated 19802 executed by D125 in favor of D6.
There is a subsequent earlier.
Yeah. Can it be proper to grant permission of C, D, AB parts of suit land to plaintiffs from D6? Whether the plaintiffs are entitled to get permanent injunction, whether the plaintiffs are entitled to get damages, whether the plaintiffs are affected court. So how much here was not
framed? This issue was not framed.
Because they admitted in the pleadings. No.
No, this issue was
They
not
are
framed.
admitted in the
I said
pleadings.
this issue was not framed.
Yes, yes. Issue will be framed only on the pleadings.
There is suit land belongs joint to court plaintiff and
So you get the maximum share.
Yes. So as per the learned trial court and my instructions from behind are that, although the Honorable High Court gave them 1/6, we are still willing to comply with the learned trial court which gave them 1/4.
Others.
I mean the cliff petitioners who are now not interested because they have sold half to them. But 1/4 also, which is more than 1/6 lot. If it goes as per the learned trial court's judgment, which gave 1/4, lot, it is acceptable to us. Right?
But the purchaser, subsequent purchaser, what about the subsequent purchaser?
Lords, now only she is interested. Petitioners are not even appearing perhaps. Petitioners have sold off the.
I have sold half my share. If I am appearing for petitioners, I have sold half to Mr. Ingor, Mr. Ingoran. They are related to me if I am appearing for.
You have sold your entire share.
Yes, to them, which I claim to be half. So therefore, I was projecting half. There was one line in evidence I wanted to show, and I'm done because as the amicus, my role is very limited. I don't want to get caught. Your Lordship will have evidence of the plaintiff, which is in the additional documents which I just handed over.
Yes.
And this is part of my note also. It begins at page 38 is Hindi. In the cross at page 48 is Hindi. And can I read the translation at 57, para 19? This is the cross of Robert Anthony, who is the plaintiff's witness. Page 57, para 19 of additional documents which I just handed over. Additional documents. It will say compilation of documents by my name. Yes.
Shamabai and Kalamabai had a half.
Yes, yes, that is what appellate court relies upon. Page 57, para 19. This is the cross of PW1. So that
57.
Yes, 57.
Para 19. Yes.
Para 19.
Yes.
All this aspect is captured in our submissions.
What is that?
Page 57, para 19. It is correct that previously the property was in name of Shama Bai and Philomena Bai. It is correct that Shama and Philomena Bai had half share in the property.
So they admit.
They are cross.
So cross examination by so and so.
Yes, the cross examination begins
of which witness?
This is PW1, So Mr. Robert Anthony.
Robert Anthony is a son
of the first wife. Yes.
So he admits.
So
yes.
in the cross further, and then we'll give two judgments, and then your Lordship may close. I will read further the same paragraph 19. Same paragraph 19, Lords, page 57 of the learned amicus's compilation.
Yeah.
Philomena has 3 children. Shama Bai has 1. Yeah. It is correct that D2 to 5 got their portion recorded in Shama Bai's name. We want an equal partition between the 3 children of Philomena Bai and 1 child of Shama Bai, but Shama Bai's daughter-in-law has sold it, claiming half share for her husband. Mutation proceedings. So, my lords, your lordships have held, and my lords, we will hand over the judgment tomorrow morning on Friday. That, my lords, 2 things. One is that, my lords, the entire deposition has to be read in entirety. 1 sentence to be picked from here and there, my lord, because the pleadings were otherwise on both sides. And the second judgment we will give that, my lord, even if there is an admission by a party, my lords, that will not change the nature of the property. Your lordships have held, my lords, in 1964-65. We will hand over these 2 judgments. Lord, the nature of the property, lordships have gone to the extent of holding that even if I admit it is an ancestral property, but documents say that it is otherwise, then even my admission against myself does not matter.
Then that goes against you.
Sorry, my lord?
It goes against you. The document itself is self-speaking.
No, but my lord, on document there is an admission in the pleadings.
Pleading and express terms of document, which will prevail?
My lord,
pleading is just your submission. Basically, your case you try to, but then when you plead something which is contrary to the express term of the document, that is
not. Document does not say otherwise, my lord, in all humility.
Okay.
Yes, sir. Lordship, my submissions have Lordship, sir. Yes, sir. So you refer to 1 or 2 decisions.
Thank you.
Very, very grateful, Milord.
Very deep.
The opportunity to learn, Milord. Very thankful to your Lordship.
We are,
no, Lord, we are
5 minutes to be appointed as a, from the legal aid is also an opportunity to learn. Deeply obliged.
Miss Swati.
Lord,
Your matter.
while your lordships are closing 2-pager and 2 judgments, can we hand over on Friday?
Further written submissions, if any, we filed within 1 week.
We are deeply obliged, Lord. Very grateful.
Okay. See, what happens is, why we have requested you to be here, a matter is over. This matter is not listed though.
I'm aware, Millets. I have spoken to my friend also, Millets, and I understand.
So you have to assist us only by filing a written submission on law.
This is on with respect to application of 125A minutes. So
see, what happens is that the cognizance is taken by the Representation of People Act. Now, Representation of People Act is not applicable at all.
I have examined it, Millets. It is not applicable.
Therefore, cognizance is taken because there is a local statute, Panchayati Raj statute. Now, if a cognizance is taken under the wrong provision or wrong act,
Yes, ma'am.
which does not apply,
That's right, ma'am.
does it make the order of cognizance vulnerable?
Look, in fact, I was going through the pleadings. In fact, in the complaint, he has also invoked the provisions of the IPC.
But the learned magistrate, while issuing orders of cognizance, is only taking cognizance under 125A and not under IPC.
And under the Gujarat Municipalities Act, this is not an offence.
Not a penal act, we call for
So it has to be under the general law or.
Therefore,
Yes.
it is not a, see, under the Gujarat Act,
Yes, sir.
it is not an offence.
It's not an.
But question is it an offence or not?
Malice.
See, filing a false affidavit, is it an offence or not?
Under the IPC, it is.
Therefore, you only want you to assist us on this, on the provision of law and the judgments as to whether the order of cognizance taken by the magistrate solely under a statute which was not applicable at all for the reason, and despite the fact that under IPC cognizance could have been taken.
No, because I can't be tried under RPA.
Understand,
No, RPA
is not applicable.
We are agreeing.
And if the cognizance is not taken.
What is the I understand that.
That's what we are.
So it is an abuse of process. In my submission.
See, gentlemen,
Yes.
the complaint under Gujarat Act and the IPC.
No, not under Gujarat Act.
No, we are not talking complaint.
The complaint is under IPC and RPA.
See, the complaint, okay, let's put it like this.
Yes.
That the complaint is under IPC alone. There can be three fact situations. One fact situation is like this, where the there can be three fact situations. One fact situation is like this, where the complaint is under IPC and the RPA. The magistrate takes cognizance only under the Gujarat Act. This is one fact situation. The second fact situation can be, we want you to examine from every angle that the complaint is only under the RPA. And the magistrate says IPC will apply because it's a false affidavit. What will happen then? Is he entitled to do so in law or not? And the third fact situation can be where the cognizance is only, complaint is only under the Gujarat Act and IPCs are not even mentioned. And the magistrate says that IPC applies in any event. Whether Gujarat will apply or not is in addition to that, IPC also applies. So therefore I take cognizance. These can be different fact situations, they can be multiple other fact situations. Our point is this, since you are challenging the order of cognizance, therefore we'll have to now say that the cognizance taken under a wrong provision of the statute or wrong statute or statute which is not applicable or a provision which was thereunder which is not applicable would not vitiate or would vitiate the cognizance order because it is an offence under a different statute of which he is empowered in law to take cognizance.
But chooses not to do so.
Sorry?
But chooses not to take cognizance under IPC.
No. Here what he does is he takes cognizance because he forwarded it. It has to be tried by whom?
No, it is 6 months, so it is triable by magistrate.
Triable by magistrate.
Magistrate.
So during the course of the trial, he comes to know that another he has taken cognizance and another cognizance is required to be taken also.
The cognizance can't be taken twice. It is only at the stage of framing of notice now. There will be pre-charge hearing. It is after cognizance, there will be a pre-charge hearing.
Exactly.
Then framing of notice.
So at that stage, I stand corrected, not cognizance. At that stage, still he can issue and say.
But I can't be tried under RPA.
RPA is different now.
Because there is cognizance under IPC. I can't be put to notice.
New sections may be added.
Can be added. Yes. That's what we want you to
And my lords, there are further facts which have unfolded. One mistake was done, affidavit was filed, then some other thing was done, then again another thing was done.
That is why trial is
There is a sequence of events, the conduct of the
Both sides may have some merit. Let's I'll examine independently.
So how soon will you do it? Because we had reserved it quite.
If millets are sitting millets during the partial hearing days, millets may keep it then. Otherwise, there's whenever millets.
No, we are here, but in any event, I'll have to expedite my disposals.
Whenever millets to direct millets.
So you tell us how soon you can do it.
No difficulty in minutes.
A week's time.
Week's time.
You just give it to, because he said sitting next.
Millets won't be hearing the matter. Millets will submissions.
We are not keeping for it.
Very well, millets.
Is it required to be?
Well, I will
Millets
suggest
are already-
it will be better if we have a 5 minutes hearing because we may have to give these propositions on law as well.
Then
5 minutes.
Then person
Or first if you not.
Millets have already indicated that.
Hearing for.
Very well, very well. We'll give our submission.
Written submission will be sufficient.
It is not required millets, but because his client, his interest needs to be protected.
Because I will
that's
have
what millets.
my submission will is I can't be subject to trial. Under a wrong cognizance order, I can't be subject to trial. I will do that.
See, as a counsel, because we know you are a very fair counsel, we will give judgment on both sides. Simple as that.
I've understood millets. I'll also examine it independently.
एक हफ्ते में
Please millets.
कोई order नहीं pass कर.
Please millets.
I'm here. No, you have to go to the root of the matter, please. My lord is rightly saying. You have to see what is the.
And then we'll have to see whether 171G and 177 IPC also there has to be ingredients of that crime. Unless there is cognizance in that case. Because there is no cognizance on 171G and 177. The ingredients of those two sections are not fulfilled. So it is required. I'll by written system.
1 week. That's
yes.
Please millets.
Great.
Please millets. Wait.